PP matter, my lord. I have submitted the papers. In Assam, my lord, rules were framed. A regular cadre of, my lord, prosecuting officers have been created. For public prosecutor, additional public prosecutor, and assistant public prosecutor. Subsequently, my lord, on 30th of October, page 12, Lord, you will find 30th of October 2023.
Yeah.
Advertisement was issued for appointment of public prosecutor as well as special public prosecutor.
Fine.
Meanwhile, my lord, since the new act is coming into force from 1st of July 2024, the entire process has been cancelled by the last page, Lord, you will find. Page 24. Page 24.
Cancellation of the.
This is the present position, my lord.
So now
Lord,
you have to frame a new rule, whatever it may be. So section 24, as per now, if
Till
you have
now
to
it is
open,
there.
then section 24 has to be followed.
I have just placed the paper, so this present position is clear before Lord. Because subsection 6 of section 24 of CRPC says, my lord, if there exists regular cadre,
It is in relation to the public prosecutor or additional public prosecutor.
yes, my lord, but then if your lordship goes to the
So far as
advertisement,
special public prosecutor.
my lord, the advertisement, lordship, you can see at page 12, there is advertisement for special public prosecutor also.
Who can it be? Special public prosecutor.
My lord, if a person is appointed as a public prosecutor, my lord, I do not know, my lord, one of them may be chosen for being appointed as a special public prosecutor, because the appointment procedure will be under section 24 in terms of the Supreme Court judgment. My lord.
We'll do one thing.
My lord,
We'll get the matter listed on in to be mentioned category tomorrow.
my lord,
Then you submit your whatever.
my lord.
Since the procedure for appointment of the public prosecutor is provided under section 24,
My lord,
and these rules, whether this competence of the state government to frame these rules for appointing, you can lay down the manner, but so far as regarding appointment of the.
I'll make my submission
you
tomorrow.
make your submission.
Tomorrow.
Yes. CA, you have to be mentioned.
Let the petition also be present, my lord.
Yeah.
Tomorrow, let the petition side also will
You
be
please
present.
inform me. Huh?
I'll inform deeply.
May it please your lordships. My lord, in respect of item number 5, I beg leave to withdraw this writ appeal, as the connected petitions have been adjudicated by the learned single judge yesterday itself.
Okay. What they have decided?
Madam,
Finally decided?
finally decided. Madam.
Okay. Wants to withdraw. Dismiss is withdrawn.
I'm right.
That's, I beg to mention item number 33 minutes. Maybe adjourn for the day minutes, item number 30.
Review petition. Let the number comes, then we'll see.
As I have a personal inconvenience for today minute.
Whatever it may be, you make a mention at that time. We'll consider
Very
it.
well.
Since it's in a hearing category, we have to.
Very well.
Yeah, please, Lordship. Lordship, I beg to mention item number 35 by taking consent from the other side, Lordship. Lordship, my senior is unable to appear today due to his personal difficulties.
Hearing matter,
Yes, Lordship.
next week, may log.
Obliged.
With please, Lordships. Lordship, pertaining to the item number 36, Lordship, the arguing counsel is out of station today, Lordship. Item number 36, Lordship, the arguing counsel is out of station, Lordship.
Let the number comes. Let the number comes. Why you have not circulated the slip in advance?
I'm with the limited instruction, Lordship.
We'll see to it. Let the number.
Obliged.
Lordship, we have filed a writ petition challenging the order of the tribunal, Lordship. Now the applicant has filed an enforcement application there, Lordship. So this is, can it be taken up on Friday or Monday, Lordship,
Next week.
next week?
Daily list for orders item 1 and 2.
My lord, I am appearing for item number 1, my lord. Yesterday, respondent number 7 has filed an affidavit, my lord. I want to, in respect of maintainability of this, my lord, this PIL petition, my lord. I want to file a reply, my lord.
Maintainability, you please satisfy us. Forget about their reply or whatever. Maybe we'll ignore that.
My humble submission before you, something is some aberration has been made, is a wrong submission made by the respondent. That is
We'll
why I was-
ignore that.
Yes, my lord.
We'll ignore that.
Yes, madam. Your lordship kindly come to the point is that in respect of maintainability is that in respect of my lord service matter, my lord, his petition, sorry, the public interest litigation was not live, my lord.
Yes.
That is the my lord point. Your lordship kindly look to all the judgment. It is in respect of appointment and promotion, my lord, not in respect of my lord excess salary of any person, my lord.
Is it not a service matter?
My humble I am
How can
submitting.
you
my-
differentiate between the,
Yes, my lord.
since only the promotion and the recruitment matters are service
my lord.
matters and regarding payment of salary to other person or emoluments. Is the,
That aspect, my lord, I shall go to the authority, my lord.
which authority?
Yes, my lord.
Yeah.
This is in respect of Honorable Apex Court has said, we kept open, my lord, in respect of whether
Fine.
in my lord, PIL petition, service matters, meter, my lord.
Read.
Yes, my lord, I am reading that judgment, my lord. The hard delay on the hard land considerable land. The division based Honorable High Court had daily imprint order dated 22/1/2000 followed by the order passing review petition dated 14/2 has declined to interfere with the selection and appointment made in the year 2000 under the Director of Education, New Delhi. The above stated appointment was challenged on the purportedly in the public interest by way of writ petition instituted in the year 2017. The High Court, on consideration of the affidavit filed by the official respondent, has come to a categorical conclusion that private respondent possess requisite qualification and all of them were eligible for the offer post. In that view of the matter, having regard to the fact that the respondent 5 to 17 have already served to almost 15 years, we are not inclined to entertain the special leave petition against their selection of appointment. However, the second reason assigned by the High Court, namely PIL, is not at all mental service matter in view of the decision of the Durjodhan Sahu and others and Jitendra Kumar Mishra, 1998 7 SSC is debatable issue and the said question is law is kept open to be gone into the appropriate case. With this, the special petition are dismissed. That has been kept open, my lord. And my lord,
That is kept open not for High Court. It is for the Supreme Court.
yes,
We
my
are
lord.
bound by the Supreme Court judgment, sir.
Yes, my lord. Then your lordship come to
They
this.
Still, this Duryodhan Sahu holds the field
Yes, my lord.
and it is
Durjodhan,
binding.
Durjodhan Sahu is the tribunal. Basically, an order has been passed by the tribunal.
Whatever
In
it
this,
may be, the
it just-
ratio laid down in that in service matters, PIL is not maintainable. That's
in
all.
respect of jurisdiction of the tribunal, that has been challenged. Now, one judgment of the, my lord, Bombay High Court, my lord,
Yes.
entitled and in excessive, that was one, my lord, in respect of judicial officers, my lord.
Yes.
I'm given, my lord, judgment, my lord. Yes, my lord. In what happened, my lord, in this, it is judicial officers, my lord, as per SETI Commission report, my lord, had given, my lord, in respect of.
Read the relevant.
Yeah, I'm reading the paragraph about judgment, my lord, 11 paragraph. Your lordship kindly come to the paragraph 1, my lord. Heard learned government pleader appearing for the appeal state of Maharashtra in support of civil application. We have heard the learned counsel in the public interest litigation. Heard learned counsel for the respondent, the learned counsel appearing for the third respondent in the PIL. By the judgment and another dated 11 August 2017, the court held that a government resolution dated 31st October 2005, by which the defined contributory pension scheme was introduced by the state government, was not applicable to the judicial officer in the state. It was held that even though the judicial officer appointed on or after 1st November 2005, they will be entitled pensionary benefit which are available to the judicial officer appointed prior to the state date. This court, however, gave an opinion of the judicial officer who are appointed on or after 1st November 2005 to continue in the new pension scheme. This court held that pension scheme which is applicable judicial officer appointed prior to the 1st November 2005 was more beneficial to the judicial officer than the new pension scheme. Moreover, this court recorded a categorical finding that the act state government applying a new pension scheme to the judicial officer who was completely contrary to the order of the apex court, including the order dated 26 July 2023. Being aggrieved by the state order, the state government special leave petition in the apex court passed in an order transferring the present PIL to it. Supreme Court has, my lord, transferred this case to the, knowing fully well that to the Honorable Bombay High Court, my lord. By the order dated 27 March 2018, the apex court disposed of the special leave petition and directed that the present PIL be returned this court for disposal in accordance with a law, with a rider that this court should not decide the issue which has been considered by the apex court for resolution, why of which Justice Reddy Commission has been appointed. Thus, the judgment on order 11 August 2007 has been final. Then your lordship kindly come to para 6, my lord. This order has been, my lord. Lordship kindly come to the para 5. Thus, in fact, the state government ought to have complied with the order dated 11 August 2017 long back. Though special leave petition was filed, the apex, admittedly, the apex court has not granted the stay. The state government has indulged of making illegal and unauthorized deduction from salary of the judicial officers who were appointed after 1st November 2005. Though the judicial officer entitled to refund the said amount along with the interest return accrued thereon. Now, by the method of transferring the said amount of GPF amount, the state government want to ensure that the judicial do not have the advantage of refund for last 10 years. That the government an opportunity to use the said amount laying the GPF fund. Therefore, the payer for clause B for transferring refund amount due to payable to judicial officer in GPF account cannot be.
What do you want to convey by this order? Where it is held that in service matter, it is PIL
My
is
lord,
maintainable.
this decision, my humble submission before your lordship is, I want to try to distinguish between the appointment and, my lord, promotion and the excess payment of salary. That is why, my lord, I want to submit this. Accordingly, the civil petition is allowed. We direct the state government to transfer the deducted salary.
Your main grievance is that this person is appointed as vice chancellor and is getting 7,000 something.
Yes.
Whatever the amount meant in excess to it, which is not permissible. This
is not permissible. And, my lord, in this instant case, my lord, my learned senior friend affidavit respondent number 7 and my lord, Agriculture University never denied this position. in their petition. And interestingly, state government and central government not filed the affidavit. They said that this, my lord,
Maintainability.
in respect of
Satisfy us on
maintainability, this,
maintainability,
my
otherwise, whether they have filed reply or supported it or not,
yes,
or
my lord.
admitted.
Because, my
that's
lord,
not-
why I want to distinguish these things, my lord, in respect of, my lord, excess payment to the, my lord, vice chancellor, my lord, it is a public money, it is a taxpayer money, my lord. The person, my lord, we will pay the tax, my lord. As a, my lord, as a citizen, my lord, I personally also paid the tax, my lord, my learned friend also paid that. It is a tax money. That is why, my lord, it petition lie. In respect of appointment, it is the individual between two persons, my lord, others, my lord. So my humble submission before your lordship that writ petition is lie, my lord.
Yes.
And I have given to authority in respect of that judgment, my lord. That judge which has been relied, my lord, 2008. এই কিতাপখন দিয়া না মই কিতাপখনত দাগ দিয়া আছে Your lordship kindly come to the truth. শনিবার কথা শুনি কিতাপখন 1998 7 SSC my lord. Para 18. Para 18, my lord.
18.
18. 1-8. The Constitution or Administrative Tribunal was necessitated that because the last pendency of cases relating to service matter in various courts in the country, it was expected that the setting up administrative tribunal to deal exclusively in service matter would go a long way in not only reducing the burden of the court, but also provide to the persons covered by the tribunal speedy relief in respect of their grievances. The basic idea evident from the various provisions of the Act is that the tribunal should quickly redress the grievance in relation to the service matter. The definition of service matter found in Section 3Q shows that in relation to a person, expression means service matter relating to the condition of service. The significance of what his cannot be ignored. Section 3B defined to the word application as an application made under Section 19. The latter section referred to person aggrieved. In order to bring better tribunal, an application has to be made. Same can be only person aggrieved by way of order pertaining to within the jurisdiction of the tribunal. We have already seen the order has been defined in explanation to subsection 1. Section 19 to all matter referred to Section 3Q service matter could be brought before the tribunal if in context. Section 14, there is no doubt that total stranger to the service concerned cannot be make application if the public interest litigation at the instance stranger are allowed to be entertained by the tribunal. The very object speedy trial service matter would get defeated. In respect of tribunal, my lord, Honorable Apex Court has said.
Yes.
And you all also kindly come to the para 12. We have heard learned counsel on both, have a lordship got it, page 279.
Yes.
Yes, madam. We have heard counsel for both the parties land service ruling have been relied on by them through in none of them question arose directly for consideration. The question as to the maintainability of public interest litigation before the defendant in answer on the provision of the Act. The tribunal having been created by the Act, scope and extent of its jurisdiction have to be determined by interpreting provision thereof. In SP Sampat Kumar, it was held that tribunal constituted under the Act were effective substitute to the High Court in the scheme administration of justice. They were entitled to exercise power thereof. It was observed that they were real substitute not only in form de jure, but in content and de facto. On the premises, the court held that the power of judicial review exercised by the High Court in service matter under Article 226 and 220 are completely excluded. Fine. It may be noticed that the order of reference that extracted in earlier paragraph is weak matter. If that view of the content prevail, approach question might have been determined. This is my humble submission in respect of maintainability of the petition, the PIL petition. My lord. I am appearing on item number 1, my lord. Only.
I am appearing in item number 2, your lord.
Item number 2. Yes.
So petition on your lordship. 226, your lordship, seeking a writ of quo warranto, your lordship. There also they have raised an issue of maintainability, your lordship, of PIL, your lordship. My humble submission is this, your lordship, since system after your lordship, writ of quo warranto, your lordship, the public interest litigation will lie, your lordship. I am relying on one judgment, your lordship,
Yeah.
Harbans Lal, your lordship, 2009, 7 SCC. 2019, 2010, your lordship, 9 SCC 642.
Yes.
655, your lordship, 2010, 9 SCC 655. First few lines, your lordship, before brief facts, leave granted. This appeal is directed against the judgment and order dated 27/4/2009, passed by the High Court of Jharkhand at Ranchi in writ petition PIL numbers 5067 of 2008, in and by which the High Court allowed the public interest litigation filed by so-and-so, respondent herein, and quashed the appointment of Haribans Lal, appellant herein as the chairman of Jharkhand Electricity Board, and directed the state government
With
to
the
make
relevant para.
lordship. Then your lordship will kindly come to para. I have this para 34. After discussing your lordship, quo warranto, when can be issued, your lordship, para 34, the finding. From the discussions and analysis, the following principle emerged. A, except for a writ of quo warranto, PIL is non-maintainable in service matters, your lord. Now this seems the issue, your lord. When it comes to quo warranto, your lordship, and since I am not directly interested in the post he is holding, your lordship, the PIL will be maintainable, your lord. And your lordship, public spirited person, your lordship, will come, your lordship, will have to come by way of a public interest litigation if you want to challenge the usurpation of post by a person, your lordship, who is otherwise not appointed as per the very provisions of the rules, your lordship.
It's by the same person.
Same person, your lordship. By the same person, your lordship, and your lordship, so far as the merit is concerned, your lordship, on that part, your lordship, I would like to, your lordship, file an affidavit in reply to the affidavit in opposition filed by the private respondent. I have not filed my reply to that, your lordship. Otherwise, on the maintainability point, this is, your lordship, my humble submission. In my humble submission, your lordship, in view of the law laid down by the Honorable Apex Court in this, my petition, your lordship, so far as the challenge to the selection and appointment of the private respondent is concerned, is maintainable by PIL.
My lord will kindly appreciate one thing, item number 1 and item number 2, challenges are different, but the person is same, my lord. If in item number 1, the petitioner has no locus, only merely changing a prayer, the prayer effectively is to oust the vice chancellor of the university, that is item number 2. And for that, he has taken recourse to writ of quo warranto. Same person, my lord.
First address in item number 1.
Yes, my lord. In item number 1, my lord, reliance has been made to Durjodhan Sahu's case. That was, though it was in the context of, my lord, the power of administrative tribunal to enter in a PIL, but that judgment has been applied by this honorable court again and again. In fact, by a division bench of this honorable court, that is, my lord, 2007 4 GLT 894. (2007) 4 GLT page 894. Therein also, my lord, challenge was to the selection of a
person. Page 890, but that's a division bench judgment. Just to indicate the issue before your lordship, my lord, paragraph 1 says, paragraph 1 is the issue involved. My lord, the petition is filed by two petitioners in the form of public interest litigation, seeking for a writ of mandamus restraining the university respondent from giving effect to the appointment of respondent 7 and 8 as professor and reader of Department of Philosophy, and also for issuing writ of certiorari. So if I may take your lordship to paragraph 9, my lord. That was, my lord, the deliberation before the honorable court. Paragraph 8 and 9, my lord.
Yeah. Para number 8.
Para number 8, my lord. Para 8, when the court made a pointed query as to the availability of any decision of the apex court on the maintainability of PIL in service matters, no such authority is submitted by the petitioner. On the contrary, Mr. So-and-so learned counsel appearing for the Nehu cited the case of
Yes.
paragraph 9, my lord. On the contrary, Mr. Sen learned so-and-so counsel appearing for the Nehu cited the case of Durjodhan Sahu and others reported in so-and-so, in which the Honorable Supreme Court has held that PIL is not maintainable service law. The aforesaid proposition of law is reiterated by an apex court in Gurpal Singh versus State of Punjab reported in so-and-so. In this case, a division bench of Punjab and Haryana High Court held the appointment of the appellant therein as auction recorder of market committee as invalid and illegal, and the said order of the High Court came to be passed on the basis of a writ petition file and style as public interest litigation. On challenge before the Honorable Supreme Court, the apex court held that in service matter public interest litigation cannot be filed and is not maintainable as such. The judgment of Punjab and Haryana High Court is set aside so-and-so. Then, my lord, going below the, okay, I will continue to read, my lord. In Nitu versus State of Punjab and so-and-so, the judgment passed in a PIL by the Punjab and Haryana High Court came to be challenged before apex court. The Punjab and Haryana High Court allowed a writ petition filed in the guise of public interest litigation challenging the appointment of the appellant as audit inspector. Cooperative societies Pirozpur on the ground that the appellant got his appointment on the basis of a scheduled caste certificate, though he was not a member of the scheduled caste committee. The High Court, by the impugned judgment, issued a writ in the nature of quo warranto, setting aside the appointment of the appellant. The setting aside of the judgment of the High Court, the apex court held in paragraph 7 is relevant, my lord. So I'll read, my lord. Para 7, as noted supra, a time has come to weed out the petitions which, though titled as public interest litigation, are in essence something else. It is shocking to note that courts are flooded with large number of so-called public interest litigation when even a minuscule percentage can legitimately be called as public interest litigation. Though the parameters of public interest litigation have been indicated by this court in large number of cases, yet unmindful of the real intention and objectives, the high courts are entertaining such petition and wasting valuable judicial time, which, as noted above, could be otherwise utilized for disposal of genuine cases. Though in Dr. Durjodhan Sahu and others versus Jitendra Kumar Mishra, reported in so this court held that in service matter PIL should not be entered in. The inflow of so-called PILs involving service matters continuous, unabated in the courts and strangely are entered in. The least of the high courts could do is to throw them out on the basis of the said decision. The other interesting aspect is that in the PILs, official documents are being annexed without even indicating as to who the petitioner came to possess them. In one case, it was noticed that an interesting answer was given as to its possession. It was stated that a packet was lying on the road, and when out of curiosity the petitioner opened it, he found copies of the official document. Wherever such frivolous pleas are taken to explain the possession, the court should do well not to dismiss the petitions but to impose exemplary cost. So, my lord, relying on all this, my lord, finally at paragraph 12, it is said they were also not following the guidelines of the Honorable Court in preferring PIL. The guidelines of the PIL, paragraph 12, my lord, the guidelines of the PIL issued by the Apex Court has now been incorporated in the part of the rules as Appendix 28 of the Guwahati High Court rules, the relevant portion so and so. Case are quoted below. Cases falling under the following category will not be entered in as public interest litigation, and these may be returned to the petitioner or filed in the PIL cell as the case may be. Number 2, service matter and laws pertaining to pension and gratuity. The aforesaid aspect above and Appendix 28 and Rule 27 of Chapter 4 have been elaborately discussed by division bench of this court in so-and-so case. And in that, the writ petition filed in the form of PIL was dismissed as not maintainable. This court is in agreement with the reasoning given the aforesaid judgment. So, my lord, this is a division bench judgment.
So far as regarding this judgment is, okay. What about this 2010 judgment thereafter?
2010 judgment.
Warranto is
True, my lord.
maintainable as per.
Co-warranto, definitely, my lord, the test of locus will be relaxed, but it will not mean that anybody can come and file a co-warranto. My lord will kindly appreciate one thing. This same person has filed 4 more. The two are listed today. 4 more are listed tomorrow, my lord. Item number 1 to 4. Again, alleging service making allegations of granting some service benefits to some employees, or my lord, some works executed by the university. Those are in the realm of tender. So he has filed 6 writ petitions, my lord. There is a specific rule of this Honorable Court to regarding filing of PIL and accept registration of PILs. At paragraph 7, it says that the petitioner has to disclose how many cases he has filed, which are pending and the status. While filing this case, he has not made a whisper about the cases pending. His bona fide is seriously doubtful, my lord. My lord will kindly see for a moment the Guwahati High Court rules, my lord. And all these things, my lord, happen in the year 2000.
Respect of that, it
Have you
is,
replied,
In, rejoinder, in,
I shall file the reply, madam.
in your rejoinder.
Yes, sir, I file a reply, madam. It is in reply, madam.
Let us,
Nothing should be done, of course, to file a reply, madam.
yes, then.
Because it's from the limit of maintainability.
No, I am on maintainability only, my lord. Because maintainability doesn't only mean locus, my lord. This appointment was made in 2020, my lord. Challenge made in 2003. 23 for 3 years, my lord. And 10 years is only remaining 10 years is only 1 year, my lord. It's already been 4 years of that incumbent, my lord. My lord, that page for 488 is the Guwahati High Court Public Interest Litigation Rules, my lord, of the same book, my lord. Page 488. And whose cause he's espousing, my lord? He's saying the student community. Students could have directly come, my lord.
Yes.
Page 488, my lord, is the Guwahati High Court Public Interest Litigation Rules 2011. I would like to take your lordship to Rule 10, my lord. Filing of public interest litigation. There are certain mandatory statements on oath are to be made by the petitioner.
Yes.
My lord may kindly see paragraph G, my lord. Paragraph G says, in paragraph 6 of the writ petition, details of the representations made to the authorities concerned for remedial actions and replies, if any, received thereto shall be set out precisely. So that is paragraph 6, my lord. If I may take your lordship now to paragraph 6 of the PIL petition, my lord. 6, he has complied with, my lord. Just a comparison between the rules and the petition, my lord.
Paragraph 6.
Paragraph 6 of the PIL petition that my lord finds at page 9.
Yes.
It says petitioner has jointly preferred a representation that he has complied. My lord, the paragraph that should follow paragraph 6 is Rule 10H, my lord. It says 10H, my lord.
Yes.
It says if the petitioner has previously filed public interest litigation or preferred letters patents, the details thereof would be set out in a tabular form giving the number of the writ petition, the status and outcome of thereof. My lord, now kindly see what is paragraph 7. It is the fact of the case. Whereas, my lord, this same petitioner has filed 6 PILs.
Prior to filing of this?
Yes, my lord, those are pending. Well, all those cases are listed tomorrow from item number 4 to 7. I am persistently saying this, my lord, before the honorable court. There is not a single whisper. All those 4 PIL, 2 pertains to service matter, 2 pertains to tender, my lord. Now, my lord, just to get rid of the question of locus, in second writ petition, same person, my lord, is just change the prayer, seeking a writ of quo warranto.
Lordship, so far as these submissions are concerned, your lordship, this is not backed by facts, your lordship. Para 17 of my writ petition, your lordship, kindly see. I have mentioned all the cases which I have filed, your lordship. In para 17, in my petition, your lordship, PIL petition. The problem of corruption of AAC was also subject matter of previous rounds of litigation before this honorable court in PIL number so and so, PIL number so and so, PIL number 1 of 2013 pending, PIL number 2, 2023, PIL number 3. What is to be hide, your lordship?
I am on item number 1, my lord. Para given?
And in fact, in affidavit in opposition filed by agriculture and environment, that is not in the pleading, your lordship. That we have not disclosed this, your lordship. It's going beyond the pleadings, your lordship.
Para 17. No, 8 para 13.
Then 1 para 13.
Item 1 para
30.
30.
They have disclosed. I'm sorry to that, my lord, but despite that, my lord, 6 PILs filed by the petitioner, my lord. Total 6. My lord, there are 2 more judgment of the Honorable Apex Court on the issue of maintainability of PIL, my lord. That is 2004 3 SCC, my lord. 363. ঠিক, আপনাকে ঠিক করে মেইনটেইন করা হবে। পেনাল্টি গুলো নিচে আছে কিন্তু।
Yes.
This is 2004 3 SCC, page 363, my lord. Paragraphs would be, my lord. If I directly go to the point, my lord, it is paragraph 16, my lord. 2004 3 SCC 363. This judgment, my lord, was referred to by the Honorable Division Bench in the last judgment that I placed before your lordship, my lord. The same
363.
363, 2004, volume 3 SCC,
Yes.
page 363, paragraph 16. This was, my lord, quoted in the division bench judgment, my lord. Paragraph 16 as page 373. As noted supra, a time has come to weed out the.
If it is already quoted.
Yes,
and
it
you
is
read
quoted.
Where is the need of?
Yes,
it?
there is the other is no need, my lord. Just I'm relying on it. This has been quoted specifically on the issue of service matters.
Yes.
Then, my lord, 2013 5 SCC. I think to hear the 2013 volume 5 SCC page. No, not that, my lord. I will, sorry, my lord, I'm so sorry. 2005 5 SCC video. 2005 5 SCC 136. The paragraph is, my lord, paragraph 12 at page 142. When a particular person is the object and target of a petition style as PIL, the court has to be careful to see whether the attack in the guise of public interest litigation is really intended to unleash a private vendetta, personal grudge, or some other malafide object. Since in service matters, public interest litigation cannot be filed, there is no scope for taking action for contempt, particularly when the petition is not maintained. if now my lord peruses how petitioner is interested, what is his, my lord, credential? Paragraph 5 of the petition. But there are direct agreed persons, like my lord, employees of the university, the students, they could have come. Or the candidates who were denied selection, who were not selected and the present VC was selected, they could have also come. At that point of time in 2020, when the selection was made, paragraph 5, my lord, will see that the petitioner is a social activist and the state president of Central Committee for Hindu Yuva Chhatra Parishad, Assam. He is also the Secretary General of World Hindu Federation, Assam State. The Hindu HYCP, Hindu Yuva Chhatra Parishad, Assam, is a nationalist organization which has been speaking out against the secessionist and anti-national forces and has also been advocating for a corruption-free society. One of the prime object of the HYCP Assam is the upliftment of the youth and the students for their holistic career development aiming at overall welfare of the nation. The petitioner has submitted a number of RTI applications to unearth the reported corruption in AAU, Jorhat, including in the matter of drawing of excess monthly payment and allowance by the incumbent vice chancellor so-and-so. The petitioner has the means to pay the cost. So this is his background. No one is interested to prefer any case. Neither the persons who participate in the selection of the DC, nor the present employees, nor the students. He, out of nowhere, my lord, comes to this court and flooded with 6 PILs, my lord. 6 PILs has been filed. Now, just to get rid of the issue of locus, he is using the word locus. Sorry, co-warrantor only at the prayer. His prayer is to issue a writ of co-warrantor. It's basically a colorable exercise on his part, my lord. And it is again, my lord, delayed by 3 years. The selection was made in 2020. PIL filed in 2023.
In PIL 36, why the points in PIL 65 was not taken?
Lordship, PIL 36 is also.
When you filed PIL 36, all the facts were known to the petitioner about PIL 65.
PIL
Whatever is there in PIL 65, those facts were known to the petitioner. It was neither mentioned nor leave of the court sought to come up with another proceeding. Is that correct?
Lordship, PIL 36 is earlier than PIL 65.
That's the same person has filed the PIL. It is not your case that you are not aware about the illegality in his appointment. Why you have not raised this point in the earlier PIL?
Lordship. So far as PIL 65 is concerned, this is related to his
Yes.
service benefit, your lordship. That I have not taken in this way.
Why? That's why only we
Because
are.
your lordship, so far as PIL 36 is concerned, when your lordship, the specific point on this is raised your lordship, we are on simply on this because we don't want to, your lordship, so far as this petition is concerned, your lordship, we don't want to club two issues together, your lordship.
Just to give him this, have a look at order to rule 2
Lordship.
CPC.
PIL 36 is only on the point of appointment, your lordship.
Yes, why?
Because your lordship, that issue did not want to bring into this petition, your lordship.
Sir,
This is
PIL,
simply a question of co-warranty. your
PIL
lordship.
36.
That's why, your lordship.
PIL 36, when you filed this PIL 36, why you not raised these issues which were there in PIL number 65?
PIL 65 is, your lordship, first of all, is not a co-warrantor, your lordship. PIL 36 is co-warrantor.
You have filed the co-warrantor PIL first,
First, your lordship.
and then you have raised this issue.
Lordship.
Why? That's why only we are asking
Lordship, we
why.
don't want to club these two issues.
Need order to rule.
Why you don't want to club? It's not your wish.
Can you read it aloud, please?
Order to, your lordship.
Rule 2.
Should to include the whole claim, your lordship.
Read.
Every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action, but a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court, your lordship.
Principles will apply.
But your lordship, probably your lordship, not in that strictly as in respect of,
Then-
since it is a question of PIL, your
Yeah.
lordship. The application of rule, your lordship, so far as the civil procedure code is concerned, your lordship. In that way, probably we
Okay,
cannot.
then this Supreme Court judgment will come into play. When a particular person is the object and target of the petition styled as PIL, the court has to be careful to see whether the attack is in the guise of grounds or some other malified object.
Lordship, that
Yeah,
nullified
let-
object, they will have to bring into the record, your lordship. That they have not, your lordship. What
We
nullified,
can, we
your
can very well presume also.
No, no, lordship, in
We
a
can
case
very well
of this
presume.
nature, and your lordship will kindly see, they have raised certain questions about delay, etc., your lordship. This, your lordship may kindly go through this judgment, your lordship, 2009 7 SCC, your lordship,
Yes.
page 1, your lordship. My locus has been challenged, your lordship. 2009 7 SCC 1. Para 109 first, your lordship. Indisputably, a writ petition, even at the instance of a visibody for issuance of a writ of quo warranto questioning the appointment of chairman of a state commission made in terms of so and so, would be maintainable, even in case by a visibody, your lordship. Locus is lordship when it,
No, Mr. Bothakur,
lordship,
there should be clarity on one thing.
lordship,
Nobody is questioning your locus here.
lordship,
You are, this PIL itself means relaxation of rule of locus.
lordship,
So you don't have any locus. That's why you have come in PIL.
lordship,
But the question is whether it is a petition in public interest
lordship.
or it is a disguised petition to attack any individual. These are the issues we look
Lordship,
at.
that's why I am.
You don't have a locus, otherwise you would have filed a writ.
No, your lordship will kindly, that's why I am pointing out, your lordship, they will have to bring some material, your lordship, to say that, your lordship, this is in this is in the guise of PIL, your lordship, we are targeting one individual, your lordship. I am straightway putting a question, your lordship, whether his selection is as per UGC guideline or not, your lordship. That's the only question.
Then why you have filed this petition after a delay of 3 years?
Your lordship,
You have
I
waited
have,
for
your
whom?
lordship,
You
I-
waited for whom? Your principal argument is that the appointment of the VC is not in as per the UGC regulations. UGC regulations were
Lordship.
very much there
lordship,
at that time when he was
Lordship.
appointed. So why it took 3 years?
your lordship, that has, since that has not been raised, your lordship, we have not explained that, your lordship, but one thing is clear.
Who has not?
Lordship,
You
lordship
are
will-
supposed to.
your lordship will
You
kindly
are
see.
supposed to explain it in advance, sir.
Lordship will
You
kindly
can't
see, since
say
your
that
lordship,
since they have not raised any objection, okay, we are raising this objection, sir.
your lordship will kindly, in that, your lordship, my reply will be, your lordship, what the honorable apex court has said on the question of delay in quorum to your lordship.
Fine.
In that judgment, para 134, your lordship,
Which judgment?
the 2009 7 SCC, your lordship,
Okay, fine.
para 134.
Great.
Indisputably, a writ of quo warranto can be issued inter alia when the appointment is contrary to the statutory rules has been held by the court in so and so versus so and so. This in so and Durjodhan Sahu versus Jotindra Kumar, this court has stated it is not for the court to embark upon an investigation of its own to ascertain the qualification of person concerned. We may furthermore notice that while examining if a person holds a public office under valid authority or not, the court is not concerned with technical grounds of delay or motive behind the challenge.
Okay.
Lordship. And your lordship, delay so far as concerned, your lordship, I have approached the authorities, your lordship, I have obtained RTIs, your lordship, thereafter, your lordship, since they have not taken any action, I have come before this honorable court.
Fine.
And ultimately, your lordship, they are not raising these points in their affidavit in opposition, your lordship. We could have, your lordship, explained it, your lordship, had they raised these issues, your lordship. Assam Agricultural University, your lordship. Had it been a case that your lordship, I have tried to get something from the university, I did not get, then I have come before this honorable court by way of filing a writ petition, your lordship, then matter would be, consideration of the matter would be different, your lordship. That is not the case here, your lordship. No, no.
Yes,
Lordship, that's your lordship, so far as
Yes.
maintainability.
anybody else?
I'll just supplement what my friend has already submitted. There's one judgment which perhaps your lordships may like to have a look at. 2013, this is Ayub Khan, 2013 4 SCC 465 on the issue of maintainability of PILs in service matters. With one short paragraph. It's just one sentence. I will read it very slowly. Even as regards the filing of public interest litigation, this court has consistently held that such a course of action is not permissible so far as service matters are concerned. And it relies on Duryodhan Sahu and onwards all the
2013,
2013 4 SCC 465. Para 15. The apex court referred to all the judgments on the issue. And this is the conclusion. Now, this is so far as maintainability of PILs in service matters is concerned.
yes,
Now, in item number 2, a judgment has been relied on and the submission has been made that when you make a prayer for quo warranto, the tests relating to locus gets diluted. The catchword is diluted. It does not get obliterated. Your lordship will have to perhaps look at the entire conduct of the writ petition. Delay being one factor. Now, my learned friend referred to the Guwahati High Court rules. There is also a requirement, if your lordship kindly comes back to Rule 10.
yes,
Sub-rule D. Your lordship will, this is a specific requirement incorporated pursuant to the judgment of the apex court in our rules. a specific amendment in para 3 of the writ petition specifying the class of persons for whose benefit the petition has been filed. And this is what I'm relying on, as to how such persons are incapable of accessing the court themselves. He makes a statement that this writ petition, this PIL has been preferred for the benefit of the students, etc. How is it those students could not have come before your lordship? An entire Assam agitation was done by students. And here he is trying to say that the students could not have to come and preferred a PIL. So when the petitioner makes a submission that merely by making a prayer for quo warranto, the entire test of locus gets obliterated, that would be stretching it a little too far. It certainly gets diluted. But that does not mean that your lordships will not look at the whole of the facts and the manner in which, firstly, he files. If your lordship has a look at I'm not troubling your lordship with the facts. He made the first representation. The appointment was made in 2020. He makes his first representation in October 22. And thereafter comes before this honorable court in 2023. Now, as has already fallen from your lordships, he files one separate writ petition because the appointment led to whatever salary and allowances were being paid. These are all connected. He first prefers one writ petition, one PIL, therefore, thereafter waits, digs up something more. Now comes up with a second PIL saying that he is drawing excess amounts. All this is in terms of the rules. And if your lordship kindly has a look at the prayer in the item number 2, prayers rather. In PIL 36.
36.
Mal.
That is the first PIL.
This is the one praying for quo warranto. The first and the third prayer, if your lordship has a look,
Page.
will itself answer the whole question.
Page.
Page 27.
Yes.
First prayer is, issue a writ in the nature of quo warranto to the respondent number 6 to show under what warrant he is holding the post of Vice Chancellor of Assam Agricultural University and to quash and set aside the appointment of respondent number 6 as Vice Chancellor of Assam Agricultural University. Now your lordship will have a look at the third prayer. Issue a writ in the nature of mandamus directing the state of Assam to make necessary amendments in the Assam Agricultural University Act 1968. Essentially, he is asking for a mandamus from your lordships to the legislature. And secondly, he is fully aware of the fact that the appointment has been made in terms of the Assam Agricultural University Act. And he tries to raise an issue that it is rather the UGC guidelines which will be applicable, not the Act, and therefore seeks a prayer of quo warranto. The conduct itself, as was being pointed out by my learned friend appearing for the university, the conduct certainly is questionable. And at the cost of repetition, as has rightly fallen from your lordships already, the salary and allowances that he is drawing is a consequence of the appointment. Why is it that you first file one, then you wait for another few months, and then file the other? There is definitely something more than what meets the eye. So that is what the apex court has repeatedly said, that it is such frivolous PILs that your lordships will curb, discourage.
Where is the judgment where it has been held that the petitioner must explain why the affected persons cannot come before the court?
That is 2008. Answer? That is MK Sharma. 2008 Sir, judgment of 2008, authored by my Lord Justice MK Sharma. Chofal. It's Balwant Singh Chofal, 2008. It is 2010. Page 2 page 2. It is pursuant to that judgment, these rules were framed. Balwant Singh Chofal. Google it. 2010, volume 3, SCC 402. Guidelines में जो clear on those. Huh? 402. The guidelines में जो later on board.
Relevant paragraph.
The directions were issued at paragraph 181. Then reading also.
Tribunal action of service condition of service to Canada December.
No, where is that paragraph, Mr. Chaudhary, where it has been observed that the persons, the petitioner must satisfy the court as to why the aggrieved persons cannot approach the court, and therefore he or she had to come to the court by filing the PI.
I'll look into it.
Where
But
is that?
based on that, this 10D has been inserted.
That's fine, but
I'll just get. Your Lordship will give me just a moment.
there is observation, there is a finding.
It is in fact based on that 10D was inserted. Questions on your project? यार बलवंत सिंह चौहान और विश्वास की गाइडलाइंस के नीचे लेता हूँ I couldn't locate that paragraph in Balwant Singh Chauhan matter. It must be some later judgment. It merely says that the credentials should be verified. And it is only in cases where the credentials are found to be bona fide, your lordships will interfere. No, yeah, this was. But in any case, my lord, of course, that is there. But 10D squarely covers what has fallen from it. That they have to satisfy that as to how such persons are incapable of accessing the court themselves. There are two parts to 10D.
Yes,
So therefore, my lord, so far as the item number 1 is concerned, the judgment squarely covered. In item number 2, the only question whether having made a prayer for quo warranto merely by virtue of that, your lordships will entertain this PR. On that, my humble submission would be, your lordship will look at the whole of the facts, not merely go by the prayer itself. And also, your lordship will also look at the prayer number 3. He is fully aware, and that is how he waits till 2022 to submit a representation. And when I'm nearing the end of my tenure, he prefers this. And there are so many irregularities, anomalies being reported every day in newspapers. Why only 6 PILs against targeting agriculture university? Why is his level of consciousness confined to only Assam Agriculture University?
he has left other matters for other public spirited citizens.
There was a huge scam in the Assam Public Service Commission selection and recruitment. He was fast asleep at that time.
He has left it for other persons, other persons
That is-
what they will do.
That is one way of looking at it. That judgment which my learned friend placed, why attack one individual or one particular university? That is another perspective your lordship will look at. I am not carrying those judgments, but uh, some of the high courts have held these PIL rules to be mandatory.
People's Union for Civil Liberties and another versus State of Maharashtra and another. 2014-10 SCC.
Yes.
65.
People's liberty for
2014 10.
2014-10. এই তাতে এই guidelines নিয়ে আমার That's all. So in my respectful submission, both these PILs deserve to be dismissed only on the ground of maintenance. And that is why we have not said anything on the merits of the case, but we have reserved our right. We have merely questioned the maintainability in our affidavit.
So far as the maintainability point is concerned, your lordship, second PIL, your lordship, 36, I have already submitted, your lordship. Only your lordship in respect of what my learned senior friends have submitted, your lordship. Regarding that, the two petitions have been preferred, one subsequently by the same person relating to salary or excess salary drawn, your lordship. As your lordship, he himself has replied to that, your lordship, saying that after digging up something more, he has come, your lordship. Probably he has got those informations later on that has come, your lordship. So far,
That is for him to.
he is
That is for him to.
that is
Why you
this-
please.
that's what.
confine
And
your
secondly, your
arguments
lordship, so
up to
far
your-
as the secondly, your lordship, so far as that part is concerned, that the rule, Guwahati High Court rules, your lordship, that the explanations regarding that why these class of persons for whom these that could not come, your lordship. My humble submission, your lordship, would be in this regard, would be like this, your lordship. Supposing if we suppose in a situation, your lordship, nobody comes, your lordship, to file, your lordship, for some reason or other. Will that be enough to allow this honorable court to allow the?
Then you have to satisfy this court that those persons were not capable or why they are not interested in filing them. Since those are the stakeholders there. They
Lordship,
are not
maybe
the
your
stakeholder
lordship,
there.
maybe your lordship, but will that not amount to allowing this illegality to continue, your lordship? That's why your lordship in that judgment of 2010 and Sanandasan, your lordship, it has been said, your lordship, that it is necessary to, that the court is not concerned with the technical grounds of delay or motive behind the challenge, since it is necessary to prevent continuance of usurpation of office or perpetuation of an illegality. That's the only consideration when it comes to co-warrant, your lordship. I may be a very bad person, your lordship. I may be a busybody, your lordship. I may not have any locus, your lordship, so far.
Even though if a bad person.
Yes, your lordship, if a person is not legally appointed as per rules, your lordship, or he is not qualified, will that, your lordship, this honorable court will allow this illegality to continue only on that technical ground? That's the question before, probably in my humble submission before this honorable court, your lordship. And that's how, your lordship, the maintainability, so far as the present petition, PIL 36 is concerned, your lordship, will have to be looked into, your lordship. Only that part, your lordship.
Last question.
Lord.
How many PILs you have filed? in your
So
life-
far as, your lordship, I
in-
have.
In your lifetime.
Lordship, I have already disclosed, your Lordship, how many petitions I have filed, and that all relates to
These
your
are the, all relates to,
agricultural university.
what about the other institutions?
Lordship, your
You
Lordship,
are-
I am a, your Lordship, I am a, your Lordship, president of a particular organization. And I have stated, your Lordship, that I have raised various issues, your Lordship, public forum. I have even gone to jail, your Lordship, for raising these issues, your Lordship. Issues of immigration, your Lordship, illegal migration, these are the issues we have been
Sir,
taking
you-
up, your Lordship.
You may have raised many concern about, even you have raised regarding the civic condition in your colony.
Maybe, your
also.
Lordship.
Yes, certainly.
Maybe, your Lordship.
PIL, how many PILs?
No, your Lordship, that I have disclosed, whatever your Lordship is in my, your Lordship disclosed to me, your Lordship, I have disclosed in my writ petition, your Lordship. More than that, your Lordship, I have no instruction, and probably he has not filed any other. Your Lordship. I am honestly submitting it, your Lordship. But that will, your Lordship.
By the way, what is the source of earning?
Funding, your Lordship.
Earning.
Earning, your Lordship. Source of earning, your Lordship, that, your Lordship, I will have to take instruction, your Lordship.
फिर भी आपको वो याद
I, as such, your Lordship, I
Since
don't.
he is engaged senior counsels, must have paid.
No, your
paid
Lordship.
heavily.
No, your Lordship,
That's
this
why
is
only
your
we are
Lordship.
asking.
No, other side, your Lordship, that too would have your Lordship shows that he has sufficient earning, your Lordship, on this side. Probably, your Lordship, I will have to take instruction, your Lordship, on that. I don't have that
No,
instruction.
we are not on that point.
No,
We are just out of curiosity.
Lordship, that I don't know, your Lordship. May have some business also, your Lordship, I don't. I have not taken any instruction on that.
Heard, yeah.
Yes, madam. I want to submit my learned senior friend, the university has submitted all the judgment in respect to appointment and selection, my lord. No one has filed, my lord, the petition, my lord, to in respect of excess drawal of salary, my lord. Excess drawal of salary is something different with other service law, my lord.
In fact,
Because-
you have to answer this question.
Yes, madam.
Just that this, at the time of filing of this second PIL regarding
sir.
drawing of excess salary, so he is drawing this salary since his appointment. He is drawing this excess salary since his appointment.
My humble submission before your lordship, that was the-
Why you have not raised this point at the time when you have this filed a co-warrantor rate
fine.
challenging his appointment or selection as VC?
My lord, in co-warrantor petition, we do not want to club together with the co-warrantor petition and this certiorari and mandamus petition.
Then it would be deemed that you have already waived this, despite knowing this, you have waived that point.
Because we are filing, my lord, three representation, my lord, that they have to take
The
care of
principle of,
the.
constructive residue
Yes, my
will
lord.
come into operation.
Yes, my lord. What happened, my lord? Your lordship, my humble submission before your lordship, that we filed three represent. Ultimately, it is a public money, my lord. Otherwise, we are the taxpayer remediless, my lord. Excess payment has been made to the, my lord, Vice Chancellor of the university. And interestingly, Chancellor has not filed any affidavit, my lord. It let him file the affidavit, my lord, in this payment of salary of the petitioner. Because in his petition, he has agitated that condition of 3.1, 3.1 should be determined by the Chancellor of the university. And my lord, they have not filed the affidavit. What is the stand of the Chancellor? That is important. And another thing is that, my lord, he is relying on judgment of the GLT, my lord, where, my lord, one Supreme Court judgment has been relied, my lord. Me too, my lord. 2007 10 SSC 614. That also in respect of caste certificate of a particular, my lord, candidate, whose candidate's caste certificate was forced. So what is my humble submission? What my lord? What is my lord? Where shall I go for the grievance? I am remediless, my lord, as a taxpayer, my lord. In respect of appointment, that is different aspect. These two person, my lord, service law, my lord, come. In respect of promotion, between two person, where taxpayer money, salary has been paid, my lord. And my lord, it is apparent, they are not denied. They are taking, my lord, health area, my lord, allowance and other allowances, my lord. Excess to 28,000 excess has been paid, my lord. Where shall I go? That is my submission before your lordship. Last, my lord, I pay my lord. I am not filing any affidavit in reply in both the cases. If your lordship allow us to file the reply.
We are simply, on merits, we are not touching the merits.
In respect of maintenance, yesterday,
We are
my
simply
lunch,
hearing on the merit, this
Yes, ma'am.
maintainability points.
last time, my lord, my senior has taken time, my lord, and he filed an affidavit in opposition in respect of maintenance. Yesterday, I got the copy, my lord.
Yes,
Yes, so that is my humble submission.
heard on issue of maintainability of these writ petitions, order reserved.
Yes, sir.
Deeply obliged.
Deeply obliged. Take it up from there. And one word has been used by the university, my lord, Marx phantom in their affidavit. That word should not be used, my lord.
Well, which word?
Marx phantom.
Much phantom.
Oh, yes, my lord.
Pass.
We are not phantom, my lord. He has submitted. In para 4.
It is not the PUCL judgment which deals with that.
As of last.
It is some other judgment.
But that I will find it out.
Item 3 and 4.
Lordship, I pray for taking up the matter after some time. Lord, there is a special bench going on in court 17. My
Special?
a special bench is going on at 10 in court 17. Kindly pick it up after some time.
Item 6.
May it please your lordship. This appeal is against the single judge's order, lordship declaring the record correction as per civil court's direction, lordship. Keeping that intact, lordship, that was against us, lordship. In this matter, the revenue authority has filed an affidavit, lordship.
What affidavit they have filed?
They have said, lordship, one of the ground is that precept was not valid after 3 years, lordship.
The only question is
Lordship.
whether the observation or the finding of the land board of revenue that the civil court judgment and decree is not binding, that is correct or not, or that is in accordance with law or not. That's the only point.
Lordship, my contention was that, lordship, at that relevant point of time, there was a notification by the revenue authority that as per civil code direction, records may not be
So
corrected.
that notification is purely contrary to the law. Despite that, the courts are bound to follow that notification.
Lordship, we have objected to that
The
record.
civil court decree, how it can be ignored? It
Lordship,
is binding.
that is true, lordship, that
That
decree
is true,
was,
that is true,
Lordship.
then nothing else.
lordship.
What remains in this matter?
But when there was a notification that civil courts are debarred from lordship entertaining the application of the parties regarding land correction, lordship. Then,
Is that maybe that notification in some other context,
lordship,
once there is the determination of civil rights by the civil court, that is binding on each and everybody until and unless it is reversed or modified. That is the position of
lordship,
law.
these are the plots, lordship, these are walk-ups by user, lordship. These are Muslim graveyards. Only Pir Sahib Dargah was there, lordship.
The facts, apart from the facts of the case,
Lordship,
the only question is whether the civil court decree is binding on the revenue courts or not. That if any other point is there, you please, any authority or any law on this point, you please mention us.
lordship, that is revenue courts, lordship decree is binding on the revenue board. That is also in the Assam land revenue also. It is there, lordship. They can correct the record correction as per revenue civil courts direction, lordship.
As per
Civil courts direction, lordship. The civil courts
once
decree, lordship.
a right is being determined
Lordship,
of a particular party by the civil court,
lordship.
whether that can be unsettled.
Lordship, in that suit, we were not made parties, only
No,
that
no,
suit was
in-
against.
In that,
government.
you were not made party because the state was
Lordship.
land was in the name of the state.
Yes, Lordship,
So,
government has, so they were
That
made
was the
parties,
need of
Lordship.
your.
We are
you
the
became a
aggrieved
party.
party, Lordship, so we objected to that record correction, showing that that precept was issued in
And
the year.
pursuant to the civil court direction, the correction of the revenue record was done by the concerned officer at that relevant time. That is also in the year 1991.
1991 on the basis of precept, Lordship, which is not valid in the year 1991 as per section article 137 of Limitation Act, Lordship. Precept is not valid till 3 years, Lordship. Limitation period is for 3 years, Lordship. Lordship.
Which is the provision in land revenue regulation which says civil court decree will be final.
118, Lordship.
118. Land revenue.
118, that is alteration of registers on decrees of civil court, Lordship. Page 100, Lordship. Limitation 127. Limitation of. Whenever any civil court makes a decree. May I read, sir?
Regulation 118. It's a regulation. Alteration of the ratio.
Chapter 4, registration part.
Rules under the land revenue regulation. Rule 118. Yes.
This alteration of registers on decrees of civil court, Lordship. It says whenever any civil court makes a decree confirming any transfer of possession of a transferable estate or gives effect to any decree transferring any such possession Such court may order the transfer to be registered in the general registers of the deputy commissioner, and the deputy commissioner shall register such transfer accordingly. So, Lordship, it is in regard to transfer of possession, Lordship, but here is the case that, Lordship, they are claiming they are the descendants of Pir Sahab, so their name may be entered in the revenue records in the Pir Sahab Dargah, Lordship. But our case is that they are only the caretakers, Lordship. So we are objecting. It's a, Lordship, walk-up property, and this is a walk-up by user property, Lordship, where registration is also not required. But Lordship, after amendment, in the meantime, we have already registered also. And Lordship, the predecessor of private respondent also admitted that this is a walk-up property, Lordship. That also I have annexed along with this appeal memo, Lordship. Page 39, Lordship, Annexure 6. The person who filed the title suit, Lordship, he himself written this letter to the chairman, Assam Walk-up Board, Lordship.
So with this letter, the degree of the civil court goes.
Only because, Lordship, this is a public property, Lordship. It's a walk-up property for the benefit of the Muslim publics, Lordship. Only the descendants of the claiming that they are the descendants, Lordship, and we are denying to that, Lordship. They are not the descendants of Pir Sahab, Lordship. Only on that basis whether they can be declared right title over a public Gorstan, Lordship. It is a Pir Sahab Dargah, Lordship. And they are taking the benefit of that grandchildren. They are trying to incorporate their name in the revenue records and make it as a private property, Lordship.
Acha, Ms. Chaudhary,
Lordship.
see, certain fundamental principles in these matters are very well settled.
Lordship.
The revenue authorities are to maintain a register
Lordship.
for the purpose of collection of revenue.
Lordship.
That has nothing to do with right, title, and interest.
Lordship.
The revenue is to be collected from the person found to be in possession of the estate.
Lordship.
So if someone is found to be in possession, or if there is a transfer of possession, then it will be entered into the register and revenue will be collected accordingly.
Lordship.
Nothing else.
Lordship.
Now, when there is a dispute as to who is the rightful owner of the land and thereby have the authority to be in possession,
Lordship.
then it is only this civil court which can decide.
Yes.
Correct.
Lordship. Yes,
The
Lordship.
Board of Revenue can hear appeal under 147
Lordship.
of the land revenue regulation against an order passed by the district revenue authorities regarding entry of names into the record. Correct.
Lordship.
Now, here is a case where in respect of the land, civil court has passed a decree declaring the title of a particular person,
Lordship.
right?
No.
So if the title is in favor of the particular entity, that entity alone can be seen to be in possession. No other entity can have the possession of the land until the decree is verified. Notwithstanding the same, the revenue board has given a finding which is in conflict with the decree.
Lordship.
The learned single judge has said it's not permissible. That too on the premise that learned revenue board says that civil court decree is not binding. It's not a question of binding or not binding. The
Lordship.
question is when a decree deals with right, title and interest, a revenue board does not have any jurisdiction to go into that.
Lordship. That is.
So whether it is binding or not binding, it is not the business of the revenue board to go into that. If there is a decree, you either pray for setting aside that decree, file an appeal or a suit. Why are you unnecessarily pursuing this matter?
Lordship, only
If
this
the
much
writ
I
petition is
have-
dismissed, it's
Lordship.
over for your clients for all time to come.
Lordship. Only this
We
much I
expected
have-
you to understand that. If
Lordship.
the writ petition is dismissed, it is over for your client for all time to come. If you still have any semblance of title, your
Lordship.
remedy lies in assailing the civil court decree in whatever manner. Therefore, we expected that at least on the second chance, you will be able to understand this nicely. You want to withdraw to pursue remedy against the decree, that you can do, but if it is dismissed, over for you. Nothing can be done. And your arguments are not attractive at all. It will not be accepted. These are not correct arguments.
Then your lordship,
Then you decide what you want.
lordship may give liberty to withdraw and approach if proper.
First to remedy.
Having argued the matter for quite some time, the net counsel for the appellant on instructions has submitted that she does not want, she wants to withdraw this writ appeal. However, seeks liberty for the petitioners to avail appropriate remedy available to them for ascertainment of their rights in accordance with law, if occasion so arises.
Lordship, and
As
deeply
the
obliged.
liberty is prayed for.
Obliged.
For hearing items 7 to 32.
May I please, your lordship? Perfect.
There is a matter in Supreme Court.
Lordship, the Supreme Court has already rendered its judgment in Technimont Private Limited versus State of Punjab. Lordship, may I please the judgment copy?
Here the judgment of this court was also there.
Lordship, the judgment of this court was not there. Judgment of this court, Lordship, I will place. Larsen
Larsen
and
and
Turbo.
Tubro.
Yes,
Larsen and
Lordship.
Tubro.
Yes, sir, Lordship.
Yes. What happened in that case?
Lordship. Firstly,
It
I will
was
place,
subjected to
Lordship.
challenge before the Supreme Court or not?
Lordship, no. But Lordship, more or less, the Supreme Court has given the same observation that was given in Larsen and Turbo. Lordship, may kindly see the Larsen and Turbo judgment first of this honorable court. Lordship, I'll just state in brief that normally, Lordship, in this case, we have challenged the power of the appellate authority under section 79, wherein they have not been given the discretion.
Fine.
Lordship. 82, the Lordship discretion is there. Section 82 is another power under revision. Discretion is there.
Which para you are referring to in this
Lordship,
judgment?
paragraph 22.
Para 22, read.
Lordship, on a totality of the consideration as herein above, as well as in view of the scope and event of revisional jurisdiction under so-and-so, the challenge to the impugned order in estimate of this court lacks in substance having regard to the limited parameters of settlement noted as above. This court in attended facts and circumstances is declined to accede to the relief prayed for. We have heard learned counsel for the parties. Admittedly, it is neither a case where assessment is ex specie unsustainable, nor a case of financial hardship. Lordship, in cases where this is there, then the court will interfere. In these circumstances, without expressing any opinion on the merits of the rival contentions, we do not found any ground to interfere with the impugned order. Appeal is dismissed. This was the Lordship order passed by the Larsen and Turbo. This was Lordship relied on by the respondents. We are also relying on this judgment, Lordship, because we are not saying that we want a blanket order.
Yes.
Already any
What the Supreme Court has said?
Lordship, I'll just place the Supreme Court judgment. Lordship, what had happened, this Supreme Court judgment had come from the High Court judgment. Lordship, High Court judgment was dealing with three things. Lordship, first question was there. Lordship, if your Lordship will see, Lordship, it's very easy. Paragraph 4, Lordship. Paragraph 4, which is at page number 4. It's very clear from the paragraph itself. Technimont, yes, your Lordship. The questions involved in the matters which were framed before the High Court were as under
Paragraph 4.
4, Lordship, which is at page 4.
Yeah.
Lordship, questions involved in the matters were framed by the High Court as under Lordship A. Whether the state is empowered to enact section 62(5) of the Punjab VAT Act. Lordship, similar provision is there in Guwahati. So, Lordship, that
We are
was
not concerned with that.
we are not concerned with that. Lordship, finally, the Supreme Court has upheld it that yes, they have empowered. Second question was whether the condition of 25% pre-deposit of hearing first appeal is onerous, harsh, unreasonable, and therefore violative of Article 14 of the Constitution. High Court has held in favor of the department. Even the Supreme Court has upheld it that no, it is not a harsh thing. But the final Lordship C, which is there, which is important, whether the first appellate authority in its right to hear appeal has inherent power to grant interim protection against imposition of such a condition of hearing of appeals on merits, so and so. Lordship, in this regard, C is the important question whether the DCT appeals should grant me the Lordship inherent in his inherent power, whether that 25%, whether he is the power to waive. Lordship, the High Court said that yes, he has the power to waive. This is the Lordship, the Supreme Court has interfered in this. The Supreme Court said that no, DCT appeals have not the powers. It is the power of the High Court only. It is the exclusive power of the High Court because it is in the statute, because the statute is not wrong in giving this condition. But the appellate authority cannot be given such power that they can waive off this 25%. But the High Court in its exercise of its power under Article 226 always have the jurisdiction to entertain this type of appeal and to see whether any condition is a very harsh in any case. Lordship, in a specific case,
The condition is only of 25% pre-deposit.
only
That's
that.
the condition.
Yes, Lordship. Lordship, section 62(5) which provides the condition of 75%.
So where is the finding of the Honorable Supreme Court?
Supreme Court, Lordship. Lordship, Lordship, Honorable Supreme Court. Lordship, firstly, Lordship, the High Court can I show the order where the High Court has dealt with the 62 the C provision? Lordship, it is in page number Lordship 6. Lordship, if I may firstly show the paragraph 6 where it has said that A and B has been answered. Paragraph 6 after framing the question. The High Court considered the relevant A and B has been considered in this first paragraph, 6 paragraph. It is that concluded that state is empowered to enact section 62(5) and the condition of 25% pre-deposit for filing first appeal is not onerous, harsh, unreasonable, and violative of provision of Article 14. Lordship, thereafter, Lordship, the C portion, relevant passages from the decision are as under, Lordship.
Page number?
Lordship, that paragraph 6 I have referred to first, which says that
this page number of this
page number 5.
is this judgment is not reported?
Lordship, it is not reported. I have tried my level best to find the judgment. I could not get the reporting. of the judgment.
Lordship, Technomint is reported in 2021 12 SCC.
I did not find.
21 12 SCC.
This judgment dated which judgment is dated
September 8.
September 2019, Lordship.
Civil appeal number 7358.
Yes, Your Lordship.
Yes, my God.
Yes.
2021 12 SCC 477. And basing on this judgment also, Lordship, our High Court Division Bench has dismissed the petition.
I will place that also, Lordship.
2020
21 12 SCC 477. And the High Court one is Lordship WPC 7672 2019.
Lordship, the last paragraph, Lordship, deals with the,
Yes, which you put.
paragraph 27.
Just a minute, ma'am,
Yes,
please.
I'm- Lordship, paragraph before parting with the judgment, Lordship. Before parting with the judgment, Lordship.
Just.
Which paragraph is it observed that the writ court can interfere in such matter?
Paragraph 27, Lordship, Supreme Court.
27.
Yes, Your Lordship. May Honorable Supreme Court Lordship, may I read? As stated in so and so, in genuine cases of hardships, records will be still open to the person concerned. However, it would be completely different thing to say that appellate court itself can grant such relief.
But madam, where it is said here, the writ court is can.
Lordship, it has referred to a judgment of P. Lakshmi Devi in the
Where is
judgment
that
of,
judgment?
Lordship, the judgment has been, Lordship, quoted over here. Lordship, the relevant portion has been quoted in this portion, Lordship.
Which para?
Yes, Your Lordship. Lordship,
Paragraph 15. Paragraph 15.
Paragraph 15, Lordship.
Yeah.
Paragraph 15 से ज्यादा important है, relying on paragraph 15. Relying on. Seventeen. Paragraph 17 is also important. But the main observation is at 17. Paragraph 17, Lordship. Paragraph 17, Lordship. Paragraph 29 is quoted. I'm so sorry, Lordship.
You are appearing in all these entire bunch.
Lordship, item number 17, Lordship.
Item number 17, the issue is different, my lord.
Huh?
No,
The
no,
issue
1
is
minute,
what
1 minute, we'll
Why,
come.
why different? You are not challenging the validity of that rule.
No, my lord.
You are appearing in which matters?
Lordship, item number 7 to 16.
7 to 16.
Yes, your Lordship. 18 to 29.
7 to 16, 18 to 29,
31 and 32.
31 and 32. So, almost, except two matters, you are appearing in.
17, Lordship.
You are in item 17.
17, my lord.
So what's the difference in
My
17?
lord, here, my lord, assessment was made under the earlier act, my lord, Assam General Sales Tax Act, my lord. In Assam General Sales Tax Act, my lord, there is a provision. Discretion was granted to the authorities, my lord, either to accept the appeal with part payment or waive the entire amount, my lord. However, my lord, while dealing with the appeal, my lord, the appellate authority has taken into account the section 79 of the VAT Act, my lord, which is not applicable to the proceeding, my lord. He was in the presumption, my lord, that success.
17 alag kar dal.
And what about 30?
Lordship. If you know, I will not be able to tell. He's there.
30.
He's saying similar, Lordship.
Similar?
Lordship, I'd like to point out one thing more, Lordship. Item number 7 to 16. Because of the interim order, appeal has been already been disposed of. The assessment order has been set aside by the appellate authority.
Then
During
these
the
are the
pendency.
infectious matters.
Lordship, 7 to 16 and 32. Only this matters.
So these 7 to 16 and
32.
this will remain.
Lordship, the Lordship, only thing is that in these cases, the assessment orders has been set aside.
Excuse me, 7 to
16,
7 to 16 and
32.
32. Assessment orders have been set aside.
Yes, your Lordship.
Then what remains?
Lordship, but for future cases, Lordship.
So
because-
future cases, what do you mean by future cases? We are not going to this do this academic exercise.
Lordship.
7 to 16 and 30.
7 to
Lordship,
16 and 32. Learned counsel for the petitioner has submitted that since the appellate authority has already set aside the assessment order in question, these writ petitions have become infectious, dismissed as infectious. That we are not going.
Lordship, this survives for Lordship, item number 18 to 29 and 31. Lordship, I don't know the fate of this appeal because I'm not been able to contact, but Lordship, it's a long pending matters. I don't know about the matters, Lordship.
Then argue the matters individually. Come.
Yes, sir.
You have to convince us to exercise the extraordinary jurisdiction.
Yes, your Lordship.
Do it.
Yes, your Lordship. Lordship, I'd like to take a judgment of GSB Cement, Lordship. I must have.
Well, madam, first of all, so you have to take a submit in each of the case, what is the hardship?
Look, section.
This
That's
item
what this
number.
is.
18. No, sorry. 18. 18 to 29.
18 to 29.
And
Lordship, Lordship, item number 18 to 29 were time barred assessments, Lordship. Lordship, when the interim order was passed in by this honorable court, the court had granted liberty to the appellate authority to take up all the matters and hear the matter on merits. So, Lordship, those matters in which the assessment order were not tenable, that were set aside. So that is why 7 to 16 was set aside, and this. Lordship, I don't know about this matters because yesterday, Lordship, the in Kolkata, Lordship, the petition, the person is there from item number, Lordship, 17 to 29. The person is there in Kolkata. I could not contact him because of that that turbulence which is there, Lordship, the cyclonic thing. Otherwise, I don't know the fate, whether it is already disposed of or whether the assessment orders have already been set aside. I don't know about that. But Lordship, Lordship, this assessment orders, Lordship, were barred by limitation. Barred by limitation.
let us see what the appellate authority has done. If the
Yes, Your
appellate authority has already decided the matter, then what remains in these matters also?
That's true.
You to complete your instructions, we'll keep it tomorrow or day after tomorrow,
Lordship, on Friday.
day after tomorrow,
Day after tomorrow, Thursday.
Thursday.
Yes, Lordship. Lordship, if it could be on Friday, Lordship, that 31 also I would have been able to address, Lordship, that the SRO, Lordship, that is from Mumbai.
31.
Lordship, that matter also, Lordship, I could have seen that whether the assessment order has been set aside. It can be on Friday, Lordship.
17 to 31.
17 to 18 to 29, you complete your instructions. Item number 31, we are posting it on Friday.
Yes. It's
Why this is a revision petition?
Lordship, because what had happened, we have exhausted one remedy, Lordship. That is why we went to Board of Revenue against these orders. So since the Board of Revenue has dismissed the matter, Lordship, we have come under section 81 of the Assam Value Added Tax Act, which provides that against the order of the Assam Board of Revenue. That is also an alternate remedy, Lordship. You can come only before the High Court, Lordship, section 81. Against the order of the Assam Board of Revenue. Lordship, over here, there is no tribunal under VAT.
So actually that this validity part is not there in these petitions.
Lordship, even though we have not challenged the validity, but we have challenged the orders itself.
Orders itself, that's another thing. Then it can't be heard by the division bench. These matters can't be heard by the division bench. These 17 to 29, these matters are not supposed to be heard by the division bench.
Because, Lordship, we have challenged the orders of the
Just a minute.
revision. We have challenged the 25% payment and the order of the Lordship Board of Revenue. Lordship, at that point,
25% you have already paid and therefore your appeal was heard.
Lordship, I did not pay my 25% because, Lordship, the matters were time barred. So we challenged that provision. We challenged that order of 25%, stating that we cannot pay 25% in these cases because we were, Lordship, facing a lot of financial difficulty.
What you were saying that your appeals were dismissed and then you approached the Board of Revenue.
Board of Revenue, Lordship, against the 25.
Second appeal.
Second appeal, Lordship. Then thereafter, Lordship, against that.
The first appellate authority has rejected your appeal on what ground?
25% payment.
25% payment. And Board of Revenue has rejected your appeal?
25% payment, Lordship. Which is a compulsory. They said that we cannot interfere because it's a compulsory deposit, statutory deposit under section 79 of the Assam VAT Act. So since you have not deposited, we set it aside. So finally, we came to before this honorable court under the provisions of section 81 of the Lordship Assam Value Added Tax Act. Lordship, the revision for the Board of Revenue can be.
Section
81, Lordship. It is, even though it is written appellate tribunal. Section 4. Lordship, appellate tribunal, Lordship, it is mentioned over here appellate tribunal, but section 4 says till the appellate tribunal is constituted, Board of Revenue shall serve as appellate tribunal. Section 4.
So there is no stay in the appeal proceedings.
No,
Only the
Lordship.
interim relief is not to take coercive measure.
Yes, your Lordship.
What
And
has happened to the appeals?
Lordship, that is the only thing I don't know because thing is that-
Complete your instructions or
Yes.
by the day after tomorrow
yes, your
in
Lordship.
these matters.
Yes, your
The
Lordship.
matters have been decided by the appellate authority, nothing remains in this matter.
Yes, your Lordship. Because Lordship, in the interim, the court had provided that the appeal can be heard on
Yeah,
merit.
that's
in the
why
meantime.
we are asking. 16 to 29, this day after tomorrow. 17 to 29, sorry. And this
32.
31. 32 already decided.
Yes, your Lordship.
31 remains. And what about 30?
Lordship, 30.
30 or 31 will already. 30 or 31 will already.
And what about 17?
17 issue is different, my lord. Here appeal was dismissed, my lord. And my lord, the assessment letter were concluded under Assam Good General Services. Act.
Then 17 file.
That could be hard on me.
Yes, what is your argument?
My lord, the assessment here involved is, my lord. 2000 assessment here, my lord. That is assessment period, my 2002, 3 and 2002, 4, my lord.
And assessment year is
First April 2002 to 31st March 2003. And second is, my lord, 1st April 2003 to 31st March 2004, my lord. I mean, this assessment were concluded under the Assam General Sales Tax Act, my lord.
Assam General Sales Tax Act 1993.
My lord.
Rule 29.
And thereafter, my lord, against this assessment order, my lord, we preferred an appeal, my lord, before the appellate authority. Along with the application for stay, my lord.
Give this Assam General Sales Tax Act rules 1993. And against this assessment order, what is the, what was the remedy available to you?
Preferred appeal, my lord. Appeal. Which are the-
In which provision?
Section 33, my lord,
Section 33
of the Assam
of the
General
old act.
Old Act, my lord.
Okay. In that section 33, there was no condition of pre-deposit.
Well, there was a condition, but proviso was there, considering the condition of the SSC, my lord, hardship. It can either reduce it or waive it, my lord.
Okay. And this authority is concerned as, where is the order of this appellate authority was dismissed your?
Page 45.
My lord, the first order is at page 30, my lord, first appellate authority, page 30, my lord.
Page 30.
30, my lord.
First appellate authority.
My lord.
Okay, read.
My lord. Hardship. So so and so authorized representative of the appellant appeared and submitted a prayer petition for waiving of 25% payment of the disputed tax to entertain the appeal memorandum. The authorized representative has cited the appellant is facing acute shortage of fund as he is liquidated all profit earning business because of financial crisis. The learned representative of the appellant has also prayed that the appellant be allowed to deposit 25% disputed amount in the form of bank guarantee. Carefully heard the contention of the learned authorized representative. The power of these appellate authorities is confined to the power conferred under section 79(5), which requires proof of payment of at least 25% of the total disputed amount. As the appellant is unable to produce the proof of payment of 25% of the disputed amount in form of treasury challan, the appeal memorandum is not admitted. Now, my lord, while passing this order, my lord, the appellate authority has taken into account section 79(5) of the new act, VAT Act, my lord. He ought to have taken into account section 33 of the old act, my lord, because assessment were drawn under the old act, my lord.
What does it say? Section 33 of the old act?
Well, section 33, subsection 6, my lord, which provides the power. No appeal under subsection 1 or subsection 2 against an order of assessment of tax with or without penalty, or against an order imposing penalty shall lie unless such appeal is accompanied by satisfactory proof of payment of tax, including payment, if any, which is admitted to be due, or 20% of the amount of tax, including penalty, if any, which has been assessed or levied, whichever is higher, provided that the appellate authority or the tribunal may, if it thinks fit, for reason to be recorded in writing and subject to furnishing of such security as such authority may deem fit, admit an appeal against such order with part payment or without any payment of the disputed amount of tax, including penalty, if any, required under this subsection, with a view to mitigate undue hardship which is likely to be caused to the dealer or person if the payment of such disputed amount is insisted on. Therefore, my lord, this discussion was there, my lord.
This 79(5), this this provision came into operation when?
On the 1st of May 2005, my lord.
1st of April.
1st of May. Thirty-three five, you said?
33(6), my lord.
33.6.
Act देना जरा। 2005 Act 2005 है। What's the full name of that act?
Assam Regulated Tax Act.
Assam Regulated Tax Act 2005.
5, my lord.
Yes.
Therefore, my lord, I have the right to consider under section 33(6) of the Assam General Sales Tax Act, my lord. And my lord, section 107 of the new act, my lord, that is repeal and saving clause, my lord. That saves my right, my lord.
Where is that?
Section 107 of the new act, my lord.
Yes. Read.
My lord. The Assam General Sales Tax Act and Assam Taxation on Luxuries Act 1997, hereinafter referred as the repealed act, as in force in the state, are hereby repealed from the date of commencement of this act. The repeal shall not revive anything not in force or existing at a time at which the repeal takes effect. B, the effect.
So which is applicable in this
two B and C, my lord.
B and C?
My lord. 2B, my lord, affect the previous operation of repeal act or anything done or suffered thereunder, or affect any right, privilege, obligation, or liability acquired, accrued, or incurred under the repealed act. My lord, I have my right to consider under section 33(6) is saved, my lord.
Any law on this point?
My lord, this is appeal is a vested right, my lord, and it cannot be divested, my lord.
Any law on this? In support of your argument.
I am relying upon para 13, 14, 15, my lord.
Para 13, 14
and 15, my lord.
Read.
My lord. The fact that the right created by operation of section 24(2) is a vested right cannot be, in our opinion, disputed. Therefore, para 14, my lord, under the Income Tax Act 1922, the SSC was entitled to carry forward the loss of the speculation business and set off such losses against profits made and from that business in future years. The right of carrying forward the set off accrued to the SSC under the Act 1922, a right which had accrued and had become vested, continued to be capable of being enforced, notwithstanding the repeal of the statute under which the right accrued, unless the repealing statute took away such right expressly. This is the effect of section 6 of the General Procedure Act 1897. Para 15, my lord. In this case, the saving provision in the repealing act is not exhaustive of rights which are saved or which survive the appeal of the statute under which such right had accrued. In other words, whatever rights are expressly saved by the saving provision stand saved, but it does not mean that the rights which are not saved by the saving provisions are extinguished or stand ipso facto determined by the mere fact that new statute repealing the old statute is enacted. Right which has accrued are saved unless they are taken away expressly. This is the principle behind section 6C of the General Procedure Act 1897. The right to carry forward loss which had accrued under the repealed Income Tax Act 1922 is not saved expressly by section 297 Income Tax Act, but it is not necessary to save a right expressly in order to keep it alive after the repeal of the old act. Section 6C saves accrued rights unless they are taken away by repealing act. My lord, as per section 107, my rights were saved, my lord. My lord, and he has misconceived.
Ultimately, if we accept your argument, then we have to remand the matter to the appellate
That much
authority
only
to take into
that much I want, my lord.
consideration. Who is for the other side? You are for the other side.
Lordship, a bit of handicap because the series matter, some of the files we have, some of the file is misplaced or not there, Lordship. But basing on his submission, Lordship, whatever he has stated, it appears that it will depend upon when the application for appeal was made because
The assessment order itself was made in the year 2000, 2012.
Assessment order
Period is of 2004.
Period is of 2004, but the final order was passed in the year 2012.
It was passed in 2008, my lord.
2008.
My lord.
No, date of fixing of
My lord, assessment order at page 16, my lord. Original order at page 16, my lord.
16.
Page 16, my lord. Original order.
Okay, yes. If it is
that could be a way.
page 16,
Is the original order, my lord.
where is the date of the order?
My lord.
Date of order is how we got this 2000 this year.
The period is written at serial number 3, my lord. Period 31/3/2003, my lord.
The period. This indicated the period,
my lord.
Not the date of decision. Where's the date of decision?
That date is not.
When was 2005 Act notified?
On 1st of May 2005, my lord.
The decision of the assessing authorities after the,
My lord.
then will it not be covered by the 2005 Act?
My lord, saving clause saved my right under the earlier act, my lord. Saving clause 107, my lord, of the new act saves my rights, my lord.
No, your right is against the order of assessment.
My lord.
That was born after the new act came into force.
But my lord, when the
The
assessment,
assessment process might have started under the previous act, but the cause of action is the order
My
which
lord.
took place after the new act came.
my lord, when the assessment were concluded under provision of the old
All
act,
your arguments could be valid if the order was before the 2005 act came.
Lordship, section 107(2)(c) says, my lord, any right privilege, my lord. My lord, I have the right to consideration under section 33 because, my lord, I will be preferring an appeal under section 33 only, my lord. I will be preferring.
Do you have any authority to back up your argument that the old act will apply in your case and not the new act?
The judgment which I have relied, my lord, perhaps it is in my favor, my lord. It says, my lord, and lordship may take up the opportunity, my lord, search again, my lord, something I find more, my lord.
Specific, the thing is that certainly if the assessment order was passed prior to this came into force of this act of 2005.
My lord.
Since your assessment order, two assessment orders
My
were passed in 2006.
My lord.
That is after this act came into operation.
My lord.
New act came into operation.
My lord.
In that situation,
My lord.
we are not fully convinced that you have a right to prefer an appeal under section 33, which has already been repealed.
But my lord, lordship, the judgment which I have relied, my lord, which says, my lord, until unless expressly, my lord, repealed, my lord. And saving clause also says, my lord.
Section 6 of the General Clauses Act, that's very clear.
My lord.
But
and my lord, this saving clause also says any right, my lord.
See, Mr. Mishra, this judgment relates to transactions which took place before the previous,
My lord.
when the previous act. In those transactions, the petitioner sought a right to carry forward
My lord.
and adjust. Correct. So the right pertaining to the transactions accrued when the previous Act 1922 Act was in force. Here is a case where the assessment order was passed after the coming into effect of the new act.
My lord.
Right. So unless you show us a decision, maybe you'll find judgments on Arbitration Act 1940 and 1996. If a proceeding is initiated and the award is passed after the coming into effect of the 1996 Act, will the award be assailable under the 1940 Act or 1996 Act? Look for some judgments on that.
I will find out, my lord. Lordship may grant me some time, my lord.
Day after tomorrow,
My lord.
Thursday,
My lord.
Thursday.
Oh, Thursday, really hard. Yes. Still on Thursday.
Item number 30 also, Lordship, Thursday. They have been from item number 30 also on Thursday. They want to along with our matters.
30,
Not our matter, Lordship, somebody else's.
70 to 31 Friday. 17 to 31 Friday.
17 to 31 Thursday. Get your instructions completed, madam.
Yes, your Lordship.
After lunch.
After hearing our side at length, one question was framed to us, Lordship. That two proceedings are presently going on. One before the administrative authorities, the other one before this honorable court. And there is a direct question to us that whether we want to we have to pursue one, which one we'd like to pursue. So my humble submission, we had a lot of deliberations at the government level, Lordship, and we have come to a conclusion and I am instructed to make submission that we would like to pursue, which we have initiated in terms of our second inquiry, Lordship. So we do not want to pursue this review any further. Lordship will give us that liberty to complete that exercise. We'll follow everything.
But where is the question of liberty? You want to pursue
Yes,
too much
because
or-
that option was given. So we have already done it, Lord. It was,
The pertinent
we have
question
already
was- no,
initiated.
The pertinent question was on the day that how can you have a parallel inquiry? Once the petition is here, how can you have a parallel inquiry?
Yes,
This
therefore,
was the-
that option was given to us, whether we pursue this or we pursue that.
Yeah.
So we pursue the other one which which is in our domain at this stage. And also we'd like to make a submission that we'll immediately reinstate her and we'll complete that exercise. We are going to reinstate her also.
Mr. Sakya, may I say? If you don't press this review, then it will be closed today. If you reinstate her, the contempt will be closed.
We are, my making submission, Lordship, to that.
Beyond that, at the moment, neither we are in a position to make any comment nor anybody. As things proceed, as
Only one submission I'd like to make. I am withdrawing this review application on the ground that we are pursuing that. That line may be recorded.
No,
That option was, the question has come from.
Just
Amalgamat বহুৱাই দিলা।
Neither there. Single bench says no further proceeding. Union bench affirms the order, no further proceeding. The common. Some arguments have been made, maybe some. If he wants to report the division bench order revise. Yes. Then by saying then reinstate the contempt. Then he's saying. So you are saying that you will withdraw the review and
Will
you
not
will also
pursue the-
reinstate her.
Will
You will
not
also
pursue-
reinstate her.
Because there was a specific question from this honorable court. That you have to pursue only one course.
That's correct. Mr. Saikia, you are right. But the question was put in this context, which we should be very clear. In principle, there is no difficulty in accepting what you are saying. But there is one technical hurdle here, and which I'm sure Mr. Chaudhary will press. That's why, for clarity on that, we have to be clear. See, the single judge has held that the proceeding against her was bad. But it's not a very elaborate order, it's a very short order. The whole matter was reopened in an appeal filed by another party. This division bench went deep into the matter and held with elaborate reasoning that the learned single judge was correct. You cannot proceed against her, so she is to be reinstated. Now the state has come in a review against that order. At this stage, the review, what will be the outcome, we can't say. But if the state withdraws the review, what happens is the division bench order revives.
That's why we are reinstating.
No, just 1 minute. Then you are saying you will reinstate. Correct. So if you reinstate, the contempt fizzles out. There can't be any contempt. To that extent, there is no difficulty. But if yes, so Mr. Chaudhary, what do you say?
No, my lord, regarding withdrawal of review petition and reinstatement, I've got no problem. But there cannot be any liberty from your lordship's side, because
We are
that
not granting
will
any
give
liberty.
them hand.
We are not granting any liberty.
That is okay.
Any liberty.
That
Not
is
at
okay.
all. There is no question of
Then no
giving any
problem.
liberty. And I think so, Mr. Zekia is also not asking for any
I'm not
liberty.
asking for any, because we have already issued the so cause notice
That's
and they have
altogether-
also participated in the proceedings.
That is altogether different thing. If they are aggrieved by that, then certainly they have, if they have any remedy, they can challenge that. That's another thing.
My lord, if they take any action after withdrawal of the review petition, then my lord, the legal
Law-
way
law will
is
take
open
its
to
own
us,
course.
we'll do.
Yes.
So that neither we're asking for any liberty.
Yes, that's all.
But one observation, because that question cropped up after lordship was set, prima facie satisfied. Because the,
No, we are not making, Mr. Zekia.
no, lordship.
We simply,
Otherwise,
you
it-
listen the order, listen the order.
We-
What we are proposing, the order is Learned Advocate General, Mr. D. Zekia has submitted that the state doesn't want to pursue this review petition and wants to pursue the inquiry initiated, a fresh inquiry initiated by it, dismissed as not pressed. That's all.
Only one thing, lordship, that the arising of that question,
Which questions?
the other day, because the matter is fixed today, because I have to give an answer. The question was whether you want to pursue the course initiated by the State Department or in
Just
the
a minute.
review. That background, little bit background will be required.
Mr. Saikia, there is a little clarification here. You see, the query was, how can you, when you are pursuing a review petition, how can you side by side proceed with an inquiry
Yes,
against the petition?
that background not only
That
on.
was the ground. The question was not that which of the two the state wants to do. That's not the question.
The question was like this, Lordship. It has come to a stage, Lordship, after a lot of deliberations, posed this question because Lordship was pleased to find that two proceedings, parallel proceedings are presently going on. In that context, this question was raised and government was asked to give a reply. That background I am only seeking.
No,
But this is prima facie apparent. We issued the notice on 26th or 28th of December. They responded to it on 1st or 2nd when the stay was granted. This honorable court verbally said that don't proceed any further till disposal.
Yeah.
That was there. That is not written, but we accepted that and we did not proceed thereafter. There are two proceedings going on.
We'll have to modify the revision then. If they want to proceed. Otherwise, they will not be proceed. If they don't press the review, they can't proceed.
But we'll keep this contempt pending. You place on record the reinstatement order.
Contempt is a different. The other day, Lordship was also pleased to say that contempt, because there is no contempt, deliberate violation was not there.
Maybe.
Yes, but we'll,
If you are reinstating
even
that
without Lordships asking, we are saying that we are going to reinstate. We want to have a level playing field for everybody.
Now, please read.
The only background may be indicated.
Learned Advocate General Mr. D. Sekia on instructions has submitted that the state does not want to press this petition since they are pursuing with the inquiry initiated by them against the
Writ petitioner.
writ petitioner, dismissed as not pressed,
Closed as not placed, Lordship.
closed as not pressed. The review petition is closed as not pressed.
And Lordship, there is a verbal instruction that order that we should not proceed in the criminal case as well as is this case. Yeah, on March. That indication
Now,
also.
now
There was no order to that.
there was no order. There was simply during the pendency of this petition.
Lordship,
Now you take it as this order is not there.
I'll leave it to you.
Yes, that's all. You take it. As-
When there is a verbal order to us, we
Yes,
follow it,
certainly,
Lordship.
yes, no, quite
There
fair.
is no
quite fair.
embargo.
There is no embargo. You proceed further and it's
Secondly, my lord, lordship will pass some order in the contempt, my lord.
Contempt, let the matter be adjourned for 4 weeks, Lordship.
No, we record your funding that Mr. D. Sekia has submitted that the government is contemplating to reinstate the petition.
Yes, that can be. And we will pursue the case.
In contempt petition, yes, Advocate General, Learned Advocate General, Mr. D. Sekia has submitted that the state government, the matter regarding the reinstatement of the petitioner is under consideration, and for that, is under consideration with the government, and for that he prays.
No, I am not seeking any place. We'll reinstate her, no issue.
He prays some time for list after 2 weeks.
Lordship.
Date is
Let it be after 15th of July, Lordship.
15th of July.
July.
15th of June, sorry. 15th
June.
of June. 15th of
List on 17th, 18th June. 14th of June.
Yes.
14th.
My lord, will kindly record that what that says, they're going to reinstate, my lord.
You were order for that.
No, it's okay. If it is there, it's okay.
Please.
The matter regarding the petition is confidential and confidential with the government, and for that,
And also one more sentence maybe here, that reinstate and conclude the ongoing inquiry. That also may be recorded, whether Lordship, Lordship, my
They have
word
simply
is,
said is under
whatever,
contemplation.
whatever,
Matter regarding reinstatement of the
because
petitioner is
our,
under contemplation. That
no, my submission may be recorded. That is not the direction from this honorable court.
we are simply adjourning the matter, and for that reason, or if even we will
No, no,
not write
my
this,
thing is
we'll
that also
take your
the
words as it
government
is
should
and we
also
can
get a
simply
fair
adjourn.
chance, Lordship. My submission is that government should also get a fair chance. When I saying on behalf of the government that we are reinstating and will conclude the inquiry. That is the submission
Sir,
I am not
inquiry-
submitting only one line. I am submitting two sentences.
Mr. Sekia, there is one catch in this. Inquiry, suppose if we pass any order in respect of the inquiry, certainly any other day, if they came before this court that the inquiry is
Immediately,
for
Lordship.
whatever the reason, then we don't want any, create any confusion in that.
Lordship, I
Please.
have a Supreme Court order in my favor that we can always reopen the inquiry. That
Sir,
order I have already
no
placed it.
problem, sir. You can very well press the whatever the order, or if
And
the
they
order
have
of the
already
Supreme Court is
submitted to
there,
our
that is law of
jurisdiction.
land, sir. That's just okay. Yes.
Fine, Lordship.
Next.
For hearing, item 33.
But this matter, I very respectfully was at pray for some accommodation, but short accommodation, but as per the convenience of this honorable court.
Now,
taken
this
the-
matter is still live.
Yes, because
How?
there's a challenge to the constitutionality of the 2017 Telecom suspension rules in this Millards. And
Supreme Court has already decided.
Millards, the Supreme Court in Anuradha Vasim Millards, if I may only address very shortly on that, in paragraph 92 of that judgment, 2023 SCC page 637 Millards, that is a citation. In paragraph 92, the Honorable Supreme Court has specifically said that we are not entering into the question of the constitutionality of these 2017 rules. So,
More or less, the Supreme Court has upheld that constitutionality.
Millards, there were certain clarificatory guidelines which were issued in Anuradha Vasim. Post that, Millards, the suspension rules have been changed a little bit. They've been modified, which has been brought on record by the union. Millards. Now, Millards, insofar as matter today is concerned, Millards, the only reason is I'm very sorry for this, Millards, because of the weather yesterday, I could not complete my research. I'm underprepared today. And only because of that, Millards, I seek an accommodation, and I've taken the consent of my colleagues also.
Learned concept for the. Yes, ma'am.
For respond number 5. I was an intervener, allowed, respond number 5, I'm supporting the writ petition.
Okay. Learned concept of the petitioner prays for an adjournment. We don't find any urgency in the matter list after 10 weeks. List, yeah, after summer vacation.
Item 34.
May it please, madam. My lord,
Yes.
my lord, the issue, although my lord involves the proceedings under SURFACE, here the petitioner has challenged the jurisdiction of the authorities to proceed, my lord. Under the, because the case of the petitioner is that petitioner was neither the borrower nor the guarantor.
Have you filed any, initiated any proceedings for cancellation of that sale deed, which you are claiming as a forced one?
I have not filed, I have no instructions, my lord. That is an agreement for sale, on the basis of which the charge was created. It was not a sale deed. Registered sale deed is in the name of the petitioner, my lord.
Agreement of sales, how can the charge can be clear?
That is, there is a specific judgment, my lord.
This agreement was going to be kind of this being traditional. He's a bona fide purchaser from us. You cannot describe it. Exactly, he can't be regulated to this. That is the reason. There's nothing to do with that.
Yes.
Your lordship, we have created an security interest in our
On
favor
the basis of what?
on the basis of agreement for sale.
Agreement for sale.
Sale, yes.
So, on the strength of the agreement of sale, title was transferred.
Yes, your lordship,
How can it be?
because it is in builder purchase case.
Whatever it may be, sir,
Yes.
ultimately, if your official has not taken care of that, how a person bona fide purchaser can be punished for that?
Your lordship, the sale deed is later on, and we are covered by security interest as defined under ZF of section 2 of the Surface Act. Your Lord.
What is that? Yes, which provision you are referring to?
Yeah, section 2 ZF. Your lordship. That is in security interest. Means in right, title and interest of any kind. So what
Just-
was happened,
just a
your
minute.
lordship?
Section
ZF.
2Z.
F, your lordship. Section 2 under bracket ZF.
Security interest means right, title or interest of any kind other than those specified. Yes, understood. So, this agreement to sale on the basis of which you have advanced the loan comes with definition of which document?
And that is an agreement for sale, your lord.
Which ZF ka which provision is applying?
Your lordship means right, title and interest of any kind other than those specified in
Means
section
Right
31.
and title of interest any kind other than those so and so created in favor of the title and includes.
And includes any mortgage, charge, hypothecation, assignment, or any right, title and interest of any kind.
So this covers the agreement to sale.
Yes, your lordship. And
Show us the law. Show us any law on this.
and your lordship, on the basis of that, we have one memorandum of entry.
Yeah,
We have one memorandum of entry.
memorandum of entry what?
That is your lordship under mortgage, for equitable mortgage, your lordship.
Yeah,
Your lordship.
so
So that creates an interest in favor of the bank, your lordship.
An agreement for sale merely gives the right to the party to enforce specific performance of that agreement
not more than.
within a particular period of time. That too on fulfilling certain conditions and nothing more. It does not create any right of the agreement holder over the property. So you
But your lordship,
proceed and
interest is in
conclude your
favor of the
argument.
bank.
Yeah,
This is
But
completely
interest
fraud
is
and
in favor
collusion.
of the bank, your lordship. Your lordship, kindly give me a short date, so I can satisfy your lordship on this entire issue, your lordship.
No, how could you
Today-
grant him loan on the basis of agreement?
Yes, your lordship, generally what was happened, if a person intend to purchase one flat, he make an application before us with the consent of the builder.
that's right.
Yes.
But he intend to purchase a flat and with the consent of the contractor and you are mortgaging that flat which he has not purchased and intend to
No,
purchase.
at that particular point of time, it was under constructed, your lordship.
So how can it be?
Right, Mr. Sharma,
Yes.
you take some time.
Yes,
In
sir.
the meantime, we'll line up some people who intend to purchase some big property.
Yes, your lordship, I will satisfy
Give
on
them
that
some
time.
Will you give us the loan?
This is the normal practice, your
Okay,
lordship,
because,
is going on.
Since I am new here,
Yes.
I'll purchase the property of X, Y, Z, any other of brother, even Suman and any other advocate who is interested to give me any property. I intend to purchase that property of crores of rupees, and you please provide me loan. I'll apply to your bank. You will provide me the loan.
Your lordship, this is a general practice here, your lordship. Any
It's a
person
general
who
practice.
intend
General practice should be supported by some law. General
Yes.
practice doesn't
on
mean
that, your lordship, I will say.
Lordship, for a moment, Lordship may kindly see section 54 of the Transfer of Property Act, my lord.
yes.
Only for a second, my lord. May I read, my lord?
Read.
Chapter 3. Sale. Sale defined. Sale is a transfer of ownership in exchange for a price paid or promised, or part paid and part promised. Sale how made? Such transfer in the case of tangible immovable property of value 100 rupees. Lordship, section 50.
These are irrelevant, Mr.
But
Chakravarti. They are saying it is agreement for sale. Why are you reading?
It
sale?
is, it is specifically
It is in
mentioned in the
registered
section
agreement for
itself.
sale, your lordship.
Agreement for sale does not create any charge, my lord. In the section itself, my lord, it has provided. Contract for sale of immovable property is a contract that a sale of such property shall take place on terms.
You also be prepared. You also be prepared
Lordship,
for that and prepare your case and then come.
lordship.
Don't come and beg. Sajjan. Yes.
Item 26.
Apply.
Wait, please, Lordship. Lordship, the arguing counsel is out of station today, Lordship.
Arguing counsel is
Out of station, Lordship. They had to go to the Johat last night, Your Lord. Till
Municipal election.
short date may be given, Lordship, next week.
Sir, was the, by the way, have you gone through the file?
I'm not in the case, Lordship.
You are not in the case.
Yes.
Just tell me. Was the prayer in the petition? Arjun,
On fourth, it may become, Lordship. It may come up on fourth, Lordship.
you can't have a choice.
Obliged.
Sajjan for Arjun. Summer vacation के बाद लगो.
Item 27.
Yes, Mr. Counsel.
And we
Yeah, you are for the state. Yes.
Right.
What about the alternate land?
Alternate land, my lord, we have already given an allotment. Now, my lord, the petitioner is, my lord, raising a plea. That is the respondent number 1, petitioner. My lord, he is raising a plea, my lord, that land is not habitable. Land is not habitable.
Habitable.
Habitable. He
Why?
has, because he says, my lord, that it is more worse of kind of a land than that it was earlier allotted to him. But the authorities have, my lord, gone to the place, made an total inquiry, and the authorities have found, my lord, there was a clear fact-finding exercise. Everything is there on record. In fact, he has filed an affidavit wherein, my lord, that aspect of the matter has been brought into the knowledge of this honorable court. Materials are very much before this honorable court. That authorities has carried out a clear exercise, my lord, without there being any malafide. And my lord, that plot of land, now he is raising a plea, my lord, that land is not fit.
he is not happy, my lord. In a sum and substance, he is not happy with that part and parcel of the plot of land. Now, my lord, the facts in a nutshell is that, my lord, way back in the year 1992, a part and parcel of a plot of land, my lord, measuring 2 kotha, my lord, 10 lesa, that was, my lord, allotted. That was allotted pro bono by the government to the writ petitioner. Writ petitioner has not purchased by that plot of land by spending his money. It was allotted, pro bono allotted by the government. Nonetheless, my lord, way back in the year 2004, 2005, at the time of holding, my lord, the 33rd National Games, my lord, the event of rowing, that was, my lord, held in the vicinity of the petitioner's land. And some part and parcels of plot of land were dug out, my lord, for the purpose of holding that event of rowing. In that process, my lord, the petitioner's land also came to be dug out. And before the learned writ court, my lord, we have filed an affidavit on behalf of the Deputy Commissioner, where, my lord, we have brought materials on record to show that, my lord, the part and parcel of the plot of land belonging to the petitioner was neither requisition nor acquisition for the purpose of holding, my lord, that event of rowing for 33rd National Games in the year 2004-2005. Under that circumstances, my lord, the writ petition came to be filed before this honorable court, wherein, my lord, the National Games Authority were also included as a party respondent, respondent number 5. Matter proceeded ex parte against the respondent number 5. And finally, my lord, the learned single judge, my lord, came to a finding, my lord, that and directed the Deputy Commissioner and the Revenue Department to either give him a suitable plot of land or compensate him appropriately. Now, the question here is, my lord, who is going to pay the money? I am putting a question, my lord, that we are not negligent. We are not negligent, and no duty was casted on us to protect.
Why you are not responsible for that?
Because, my lord, the land was allotted. We are the district administration, the revenue authorities. It is for the petitioner. If someone has caused damage, it is for him to compensate. It is not the case of the petitioner.
It is during national games.
National games. And national game, national.
Some rowing
Rowing event, my lord, for the purpose of holding the rowing event.
So then you complain that. Alternative land. Comply with the judgment. There are any alternative plan. What is the problem with the land allotted to you? You are appearing with the private respondent.
My lord, yes, my lord, but I on behalf of Mr. Q, I mean, have some difficulty. But, my lord, as
You
per-
should have, you were sitting here and then he started arguing and you are sitting here seeking for time.
My lord, his lordship permitted me submit, then on behalf of Q, Ahmed, then I will submit, my lord.
What do you mean by?
Only thing is that, my lord, they are allotted the land. What happened, my lord?
Like you are a Bharati and sitting there until unless the man comes from the home, ask you, please eat, otherwise you will sit there, na?
Sorry, my lord, that.
Arjun.
John.
Arjun.
All right.
Item 38.
I'm obliged.
My lord, the settlement given by the settling authority has been interfered by the, my lord, the landed single judge. The appellant before lordship was the highest valid bidder. And the settlement was, if your lordship would kindly come to the settlement order, that is at page 51. My lord, when I read 2-3 paragraphs, my lord, entire picture would be clear. I'm reading from that subpara starting with accordingly DC Morigaon, my lord. Accordingly, DC Morigaon invited tender. Page 51, Annexure J.
Yeah.
Third subpara, the sentence starting with accordingly DC Morigaon.
Yeah.
Accordingly, DC Morigaon invited tender with issue of NIT dated so and so, while fixing annual government revenue of fishery at 11,51,205, in response to which 12 number of tenders were submitted. Preliminary scrutiny of the tender was made by the committee constituted by DC Morigaon, while order dated so and so, and the comparative statement was prepared, signed by members of the tender committee, including the DC herself. The committee noted the status of each bidder, so as to the documents submitted in terms of NIT, and forwarded the proposal to the government, while later dated so and so. Lordship may kindly skip over to the next page, page 52. Now, Teteliguri Nobojyoti MSS Limited, District Morigaon, that is the writ petition, respondent number 4 in the present appeal. The society has offered bid value of 2 lakhs and odd at the rate of 37 lakhs per annum, which is highest. The fishing experience certificate is issued by one fishery extension officer instead of district development officer Morigaon in the name of the president of the society and does not cover all the members of the society. This is one lacuna. The neighborhood certificate is issued by DFDO Morigaon, but concerned revenue circle officer is only competent to issue such certificate as per government circular dated so and so. No attested resolution of the society authorizing the president to submit tender is found with the tender. Now, my lord, this third is very important because there is a purpose which, my lord, fishery rule seeks to achieve. Because in the name of society, somebody else cannot derive the benefit. Then, my lord, will kindly come to 4. Pakori Duba means Som by Somiti Limited, District Morigaon. That's the appellant before lordship. The society has offered rupees 1,99,85,000 for 7 years at the rate of 28,55,000 per annum, which is the 5th highest. All documents submitted with the tenders are found to be in order. So, my lord, amongst the 12 tenders, these are the 2 serious contenders. I will not trouble your lordship with the facts of the others. Then please come to page 53. The sentence starting with towards the bottom, from the above government is of the view. At page 53.
Yeah.
From the above government is of the view that there appears to be wide publicity of the NIT for which 12 number of societies, 10 from Morigaon district and 2 from Kamrup district participated in the settlement process. Out of the total bids, only 3 bids were found valid as per the document report submitted with the tenders in terms of NIT as shown below. Pakori Duba, that's the appellant, which has offered 1,99,85,000 for 7 years at the rate of 28,50,000 per annum, is the highest valid, overall 5th highest, and members residing in the notified village as per the registration certificate are within the 5 kilometer radius of the fishery as per neighborhood certificate. Mayong, that this is important, my lord. Mayong Hit Hadini Sambai Somiti District Morigaon has offered 1,22,50,057,000 for 7 years at the rate of 17,51,000 per annum. Is the second highest valid bidder, and the members residing in the notified villages as per registration certificate are within 3.28 kilometers and 4.2 kilometers of the fishery as per the neighborhood certificate. Then Motsya Gandham Motsya Bebokhai Sambai Samiti Morigaon has offered 1,12 lakhs and so for 7 years at the rate of 16 lakhs and odd, which is the third highest valid bidder overall. The members reside in the notified villages as per the registration certificate are within the neighborhood of the fishery as per the neighborhood certificate. Thus, the government is of the view that bid offered by Pakoriduba Motsya Sambai Samiti Limited, Morigaon at 1,99,000 and odd for 7 years at the rate of so is the first highest valid bidder overall, fifth highest, and members reside in the notified villages as per registration certificate within 5 kilometer radius of the fishery as per neighborhood certificate, which fulfills the provisions of Rule 12 of the Assam Fishery Rules. Accordingly, government is pleased to settle so at rupees with effect from the date of handing over possession after completion of all required formalities as per the provisions. So, my lord, though I was fifth overall and the petitioner was highest, but in terms of valid bidder, the appellant is the first, then second and third are these two societies, Mayong Hit Hoti Khadini and Motsya Gandha Motsya Bebokhai Samiti. And if at all, my lord, in my absence, anybody is to get this settlement, these are the societies will get, not the writ petitioner under any circumstance. Now, my lord, this settlement was interfered with by the learned single judge basically on the ground that highest bid was ignored. And secondly, a very erroneous view has been, my lord, taken by the learned single judge that in fishery settlement matters, revenue is an aspect which also matters. My lord, in fact, that's a very wrong proposition, my lord. A full bench of our High Court way back in 1980s has said, my lord, the purpose of fishery rule is to not fetch revenue for the state. The purpose of fishery rule is to ensure that the people who are residing in the, my lord, neighborhood of the fishery gets the fruit of settlement, because there is unemployment, there is so many other factors. Now, there is another aspect, my lord, why the highest bid was cancelled. There is a notification at page 134. Now, this notification was not followed by the writ petitioner. That's why, my lord, 18th of January 2018, there's a notification issued by the Fishery Department. A lot of anomalies, discrepancies have been observed. Page 134 below.
This is by
It is issued by the government of Assam in the Fishery Department.
2018.
Yes, madam. A lot of anomalies, discrepancies have been observed while verifying the tender documents forwarded by the Deputy Commissioner SDO pertaining to settlement of 60% government fisheries by government in Fishery Department. As a result, most of such settlement orders are challenged by aggrieved parties before the Honorable High Court. It is therefore felt that there is a need for streamlining the procedure for submission of information document with the tender so that there is uniformity in all such tender through notice inviting tender floated by Deputy Commissioner SDO to maintain transparency and avoid legal complication. Further, it is felt that this will help in submission of competitive bid with authentic document, which will augment the state exchequer with increased revenue from the fishery sector. Now, accordingly, it has been decided that the following clauses are to be included in the notice inviting tender for settlement of 60% government fishery. For example, my lord, the 100% actual fisherman certificate, it has to be issued by the Assistant Registrar of Cooperative Societies, not by any other authority. Similarly, my lord, the neighborhood certificate is to be issued by the concerned Revenue Circle Officer. Then fishing experience certificate is to be issued by the District Fishery Development Officer. Then Bakizai Clearance Certificate is to be furnished by the Bakizai Authority. So this is how, my lord. Basically, it's an exercise undertaken under Article 162 to, my lord, supplement the fishery rules, where these aspects are not dealt with. Because it was the experience of the government that lot of, litigations, took place on account of submission of document by authorities other than the prescribed. So to streamline this, my lord, this was done. Now, we have already, in the settlement order itself, my lord, if your lordship would kindly come back to the settlement order once, my lord, at page number 51, sorry, at 52, as far as the writ petitioner is concerned, kindly see, my lord, the fishing experience certificate was issued by Fishery Extension Officer, whereas it is the DFDO, District Fishery Development Officer, should have issued. Secondly, my lord, neighborhood certificate was issued by DFDO, but it is the concerned Revenue Circle Officer who is competent to issue. Thirdly, there was no authorization on behalf of the president to submit the bid. Maybe, my lord, the society never bidded for the bid for the fishery. Maybe the president in his personal capacity did it. The purpose is not to help the cause of the president or the secretary. Purpose is to ensure benefit upon the actual, members of the cooperative society. So these are the reasons it was not given. Now, my lord will kindly come to the impugned order. Now, learned single judge has dealt with the issues.
Start from para 17.
Yes, precisely. At page 129. Mr. S. Bothakur, learned counsel for the petitioner in WPC, in his rejoinder has drawn the attention of this court to the comparative statement. He demonstrates in column 2 only name of representative have been written uniformly for all the bidders, and therefore it cannot be argued that society is not interested party. In any case, the learned counsel submits that a similar case regarding certificate in the name of president has been settled by this court in case of Malegaon Govindapur Fishery Cooperative Society by judgment dated so-and-so, which has also been upheld by a division bench of judgment of this court in writ appeal number so-and-so. Bothakur learned counsel has also placed before this court the case of Gauripur Fishery Cooperative Society reported in so-and-so, wherein this court has expressed doubt regarding applicability of this circular dated 18/1/28 and also regarding its publication in Gazette. Then para 20. Bothakur learned counsel also makes a very important contention that as per Gazette notification, there is a requirement to incorporate the conditions of the circular in all the NITs, which admittedly have not been done in the instant case. Lastly, he submits that there is a huge difference in price offered by his client and private respondent, and in the matter of which faces revenue, the fishery offered plays an important factor. To appreciate the contention, let us examine the reasons cited to reject the bid of the petitioner. There are apparently 3 grounds of rejection. It is, however, to be noted that price bid of the said petitioner is found to be the highest. 3 grounds are that fishing experience certificate is issued by the Fishery Extension Officer instead of DFDO in the name of the president of the society, does not cover all the members of the society. The second ground is that neighborhood certificate issued by DFDO Morigaon and not by the Revenue Circle Officer, who is stated to be the competent authority as per the government circular. Thirdly, no attestation of the resolution of society is authorizing the president to submit the tender was found. In response to the said grounds, it is found that first ground of rejection is squarely covered by the decision of this court in Malegaon, which has also been upheld by so. I'll show, my lord, the judgment was on a different point. This court.
Show the judgment.
Yes. My lord, that judgment never took note of this circular dated OM dated 18/1/23.
18.
Yes. 18/1/18. Sorry, my lord. GLT আছে নেকি 2021-5 GLT 107 এটাই কপি আছে নেকি? আমাৰ টেন্ডাৰ নোটিছটো কিমান আছে যে? Yes. My lord, I have gone through the judgment. I couldn't find any reference to that OM dated 18/1/18.
Yeah,
2021 5 ZLT.
yes.
Yes. My lord, if your lordship would kindly come to paragraph 3.
Yeah.
The petitioner is a registered cooperative society in the district of Bongaigaon with registration number consisting of 100% fishermen belonging to the scheduled caste. The area of operation of the fishery society amongst others are Malegaon, so and so, so and so, all under earlier Golpara subdivision, which are presently under Bongaigaon. The petitioner society claims to have adequate fishing experience. Pursuant to notice inviting tender dated 24/5/18, the settlement of the fishery in question for 7 years, the petitioner society, which was eligible in all respect, had submitted its bids. Among others, there was a requirement of a Bakizai clan certificate, neighborhood certificate, experience certificate, annual settler statement of return, etc. On opening of the bids, the bid of the petitioner was found to be so and so, whereas bid of the respondent number 8 was found to be so and so. It was, however, held that petitioner society was not within the jurisdiction of the Kualpara district and therefore not entitled to submit the tender. The said information was communicated to the petitioner, while later dated so and so. Subsequently, by an order dated 2012/18, respondent number was issued the settlement order at the price offered. The order further disclosed rejection of the bid of the petitioner on the ground of inappropriate fishing experience certificate, improper Bakizai clearance certificate, also a neighborhood certificate. So, my lord, the bid of respondent number 8 was accepted, and the bid of the petitioner, though he was a higher bidder, was not accepted. Now, my lords will kindly come to page number para 21. Para 20 refers to the contention of the parties. Para 21. Impugned order dated 2012/18 by which bid of petitioner has been rejected lays down 3 grounds for such rejection. The first ground pertains to fishing experience certificate. The petitioner in support of fishing experience certificate has annexed a certificate issued by the district fishery development officer. Though apparently the said certificate appears to be in the name of one Govindo Chandra Das, it is clearly mentioned in the certificate that Sri Govindo Das is the president of the society. The certificate is also required to be read along with the certificate dated issued by the competent authority, which certifies that petitioner society consists of 100% scheduled caste actual fishermen with duly registered. The further fact which should have a material bearing in this case is that on many earlier occasions, petitioner society has been allotted fisheries on lease, including the present fishery, where the same condition was prevailing. In this connection, immediate reference can be made to communication details and so. So, my lord, lordship may kindly skip that. Now, at para 22, the learned single judge, my lord, deals with the Bakizai clearance certificate. Now, my lord will kindly come to para 23. This is regarding the third ground, namely resident of the district. Because apparently, my lord, he was a resident of Gwalpara district. On that ground, it was rejected. Now, para 24 deals with the fourth ground. Then, my lord, para 25, it takes note of MS Gill's proposition. But in the judgment, I don't find any reference to this notification of 18/1/18. That is the precise argument which we advanced when this appeal was admitted. So, my lord, if 18/1/18 has the force of law, then if that is not followed, end of the day, my lord, even in it's a statutory contract, unlike a commercial transaction in any other tender.
Here, even here also, my lord, they are supposed to follow the prescription in the tender read with the rules. Now, if you do not comply with the requirement of the rules, then my lord, question of highest bid will or financial bid will come only when other things are equal. If other things are not equal, my lord, financial bid is not even a relevant criteria. It is only when parties are on the same footing, my lord, then the bid would come to play a role. Now, here is a case, your tender is defective. So, my lord, the learned single just said that it has been dealt with in earlier case. It has not been dealt.
That is only the sole ground on the basis of is this.
Yes.
Only this.
Yes, my lord. Basically, the second ground is, my lord, since he has offered higher bid, therefore he should be accepted. That is also there. I'll show, my lord. Para 26.
Yes.
It is also a settled position of law that in matters of settlement which are made to fetch revenue, price is one of the paramount consideration. In this connection, one may gainfully refer to the decision of this court in Dhaniram so and so, wherein it has been held that public interest is of paramount consideration for settlement. This court in so and so has categorically held that in matters of settlement which earns revenue for the government, the paramount consideration is public interest. Of course, my lord, nobody is disputing about, public interest. And reference to Tata Cellular was totally uncalled for, my lord. If your lordship to kindly have the fishery rule for a moment, it was not a commercial transaction. It was a settlement under a statutory scheme. If your lordship would kindly come to Rule 12, which deals with this 60% category fisheries. Rule 12. Except as a lordship's got it, Miller. Rule 12. Well, in my book, it is page 15. In those, except those referred to in sub-rule number 8B above, all registered fisheries shall be settled under tender system of sale in place of sale auction, provided that government shall settle 60% category fishery with special category of cooperative societies, non-government organization, and self-help group consisting of 100% actual fishermen in neighborhood of the fishery concerned by tender system. Now, my lord, the proviso makes it clear, my lord, that this settlement can be enjoyed by a society which is comprised of 100% actual fishermen. It is in the neighborhood of the fishery, and the settlement can be by way of tender. Now, to find out, my lord, who is a fisherman, who will issue the certificate, whether the members of the society are in neighborhood of the fishery, by way of that executive instruction under Article 162, the authorities were specified. Now, if those prescriptions are not followed, if a tender is rejected on the ground, can it be said it is arbitrary, my lord? That's the point. So, my lord, it's a statutory settlement. It can't be construed to be a per se commercial transaction. Here, there is a purpose. That's why, my lord, there is a full bench judgment of our High Court, where in that Aurobindo Das versus State of Assam, where this Honorable Court has said, my lord, that the idea is not to fetch revenue for the state. Idea is this group of people who are otherwise backward. So those people who are living in the neighborhood of the fishery, there is no competition amongst themselves. So they can get the benefit of the fishing because their only mode of avocation is fishing. So therefore to say that in settlement of fishery under the fishery rule, the price is of paramount importance. In all respect, I'll submit, my lord, it's an wrong observation. That's not correct. And secondly, my lord, end of the day, if you're not following the prescription, the authority is acted. So what is the arbitrariness? Is it such a view which, my lord, nobody else can take? And learned single judge has interfered with on the ground, which in my humble submission is not correct. Therefore, my humble submission is, my lord, the learned single judge has committed an error of law, serious error of law in arriving at the impugned conclusion. And therefore, my lord, the order needs to be interfered with.
What about today's position?
Today's position, my lord, there is a stay order operating. When we moved the appeal, there was a stay. So, my lord, now we are continuing with the settlement.
You are done.
Yes.
May I please, bro? On this side, your lordship, learned senior counsel D Das was supposed to argue the matter, your lordship. Since he is on lakes, your lordship, I will, your lordship. First of all, your lordship, I want to take your lordship to page 134 again, my lord.
134.
That's the notification on which learned senior
18/1/2018.
lordship. May I read this, your lord? A lot of anomalous discrepancies have been observed while verifying the tender documents forwarded by Deputy Commissioner SDO pertaining to settlement of 60% government fisheries by Gulf Fishery Department. As a result, most of such settlement orders are challenged by aggrieved parties before the Honorable Court. It is therefore felt that there is need for streamlining the procedure for submission of information documents with the tender so that there is uniformity in all such tenders to notice inviting tenders plotted by deputy commissioners to maintain transparency and avoid legal complications. Further, it is felt that it will help in submission of competitive goods with arithmetic documents, authentic documents, which will augment the state exchequer with increased revenue from the fishery sector. This is the one of the reason why this notice was issued, notification was issued. Now, in this connection, it is worthwhile to mention here that in many cases, the lease value assessed by the DC SDO with the help of concerned district subdivisional fishery officer often have wide variation with the bids submitted with the tenders, which in some cases are found to be exorbitantly high compared to annual lease value fixed by DC SDO. It is that it does appears that in such cases, the concerned fisheries are undervalued. In a few such cases in recent times, the Honorable High Court has also expressed adverse view in case of such huge disparity. As such, DC SDOs should ensure that the valuations suggested by DFDOs are proper based on ground situation. If necessary, the concerned revenue circle officer assisted by LR staff should also be involved in the process of assessment of revenue of the fishery along with the fishery. Accordingly, this is important, Your Lordship. It has been decided that the following clauses are to be included in the notice inviting tender. For settlement of 60% Gulf fisheries, then documents to be submitted by DC DOs along with the tender documents by the tenderers. Now, the mandate of this notification, Your Lordship, was that these conditions, condition number 1 to Your Lordship, 9, should be incorporated in the tender notice, Your Lordship. But in our case, Your Lordship, these conditions were not incorporated in the tender notice, Your Lordship. Now, Your Lordship, this notification, if it will be applicable against us, the condition
was issued when?
Your Lordship, on 18 January 2018. Your Lordship. Now, Your Lordship.
So even though if they have not mentioned these conditions in the NIT, this effect of this order notification is wiped out.
No, Your Lordship, ultimately, your Lordship, what the learned single judge has, Your Lordship, Honorable single judge has held, Your Lordship, in it. In his judgment, Your Lordship will get it, Your Lordship, at para 24, Lordship. As regards the Gazette notification dated 18/1/2018, though certain doubts have been expressed by the court in case of Gauripur Fishery Society regarding its application, and also the question of its publication in the Gazette, the said notification being placed on record, which is in the form of Gazette notification, this court is of the opinion that the said point will not act as a hurdle for this court to acknowledge the said notification. It was acknowledged. Then, however, more than its existence, what is to be decided is the applicability of the conditions of the said notification in the tender process. Sri Sharma, Learned State Council has strenuously argued that the Gazette notification is of the year 2018 and NIT is of the year 2021, and therefore it cannot be assumed that all the intending tenderers are not aware of the requirement of law. However, having taken into consideration, the court also cannot ignore the condition of the Gazette notification, which requires that all ensuing tender process have to incorporate the conditions given in the Gazette notification, which admittedly has not been done. It is trite law that while applying a notification, it cannot be done in a way that only those in favor of the state would be made applicable and those which are against cannot be applied. If the Gazette notification is actually held applicable, the same has to be made applicable whole hog and not part of it. This is the, Your Lordship, our case, Your Lordship. Now, Your Lordship, if it is to be applied, it is equally applicable for the state. Now, what had happened ultimately, Your Lordship? They have not incorporated these conditions in the tender notice. Now, while Your Lordship, the tender papers of the tenderers are evaluated, Your Lordship, they bring in these conditions as Lordship to evaluate the tenders, Your Lordship. And by that way, Your Lordship, this amounts to, Your Lordship, applying a hidden criteria, Your Lordship, which has not been disclosed.
Social justice. Beneficial scheme, beneficial scheme. More than a tender. This is the patient experience.
Yes.
Lordship, now your lordship, the
Yes.
my lordship, so far as this notification is concerned, your lordship will, I have shown your lordship, the purpose of this notification is to augment revenue, your lordship. Now the state
Augment revenue.
augment revenue, that's why your lordship, it says with increased revenue. Further, it is felt that this will help in submission of the competitive bids with authentic documents which will augment the state exchequer with increased revenue. But now,
But you are reading one line, but earlier they have also given the reason for issuing the circular since the litigation
lordship,
is coming in the courts and therefore to clarify the
lordship,
situation.
situation, your lordship.
Yeah.
Now, your lordship, that's why, your lordship, we have no problem with this notification. But your lordship, there is two parts in it. One part is your lordship, which was to be performed by the state authorities, your lordship. And then your lordship, the next is tenderers, your lordship. Now, state's parts is this, your lordship, that they will have to say all these things in your lordship in the tender itself, document itself, NIT itself. That's why, your lordship, accordingly, it has been decided that the following clauses are to be included in the notice inviting tender. They did not include.
If you mean to say that if these clauses are not included,
Lordship.
were not included in the tender notice, then they can't press for it. You please
That's
comply with
my
this.
submission. In part, they cannot press this into service, your lordship. That's my submission. And your lordship will kindly note, revenue is one of the factor. This honorable court, your lordship, division bench of this honorable court has held that so far as fishery rules are concerned.
It's like that revenue is important, but can't be the only
Sole.
factor.
Only factor.
Yeah.
But here, your lordship, in the had this been there, your lordship, that I am submitting a higher bid, but I have not followed the tender conditions, your lordship. Then matter would have been different. They have not.
Then you are arguing. No. Then your argument can be counterproductive.
Lordship.
Because you are saying that revenue is not the concern or should not be the concern.
Lordship.
And the learned single judge interfered the matter only on this ground. Your bid was high.
No, your lordship, that is not the only ground.
This is the one of the ground.
One of the ground. That's what your lordship. That's one of the ground, not the. Or had this not.
Revenue is not at all matters. Then where was the question of learned single judge to say this?
No, your lordship, this is because your lordship, in fact, your lordship, one judgment, your lordship, that is right.
Mr. Bhattacharya,
Lordship.
please respond to this.
Lord.
Thereafter, there may not be need for much labor. You see, in a tender matter, under 226, the court is to see whether the parties have been treated fairly and in an equal manner.
Lords.
Whether the decision-making process is arbitrary or it is in accordance with the rules.
Lord.
These are the only two things.
Lords.
Whether the decision is right, wrong, we are not concerned. And in this case also, we will not be concerned. Now, it is the government to decide what kind of revenue is okay, what kind is not. The government has approved and awarded this fishery. So the government knows, correct? Now, is it your case that this circular has been applied differentially to you and the appellant? In your case, it has been applied in a stringent manner. In their cases, it has been relaxed. Is that your case?
No,
Listen,
that is not my case.
Listen. If that is not your case, this circular of 2018 is issued in the name of the governor.
Lords.
Even if it is not a statute, it will have a force of a statute. It is notified, right? If they have applied these circular clauses to arrive at a finding that your client did not submit the document in the manner prescribed by the government, and if you can't show that a differential treatment has been issued to the private respondent, then revenue can't be the only criteria. Where is the scope of interfering with the order of settlement? Please address the court on that.
Lordship, my case is this, your lordship, that the decision-making process, your lordship, is vitiated, your lordship, because that decision-making process is arbitrariness is crept into that.
Why is that?
This is because, your lordship, that's why I am, that since these terms and conditions referred to in notification dated 2018, your lordship, these were not part of the tender, your lordship. It has tender notice does not prescribe that this particular certificate is required to be issued by so and so.
So is it mentioned that unless it is included, it will not be applicable?
No, your lordship, the language is this, your lordship, that your lordship, it is not written in that way, your lordship, but what we can infer from the language, your lordship, is that it will have to be included, your lordship. That's why it says, in this context, it has been decided that the following clauses are to be included in the notice inviting tender for settlement of 60% of fisheries, your lordship.
Okay, you please address us on these points and then.
Lordship, then your lordship, documents to be submitted to DC's SDOs along with the tender documents by the tenders following our documents shall be insisted upon with the tenders while floating the NIT or settlement of fishery by the DC and SDO. Now, your lordship, that's very clear. While floating the tender, this should be insisted. So, your lordship, it is equally applicable to the tendering authorities. Now, tendering authorities did not do so, your lordship. Now, your lordship, I submitted the documents, your lordship, that the neighborhood certificate, this is not by the revenue authorities, by the fishery officer, your lordship, my neighborhood certificate. Now, while considering that, they bring in these conditions, your lordship, this notification, your lordship, about which they have not disclosed. They have not even disclosed that the evaluation will be conducted on the basis of, will be done on the basis of this notification. That has also not been referred to in the NIT, your lordship. Ultimately, the criteria they have applied, these are not disclosed in the tender. And these are all hidden criteria, your lordship, they have applied. And virtually to oust the
notification was in the public domain.
Lordship, it is issued by the gazette, issued through gazette notification, your lordship.
Then what remains? What is the other way out for the government to publish a document? Gazette notification, publication and gazette notification means known to every person.
Lordship,
That is it.
no, lordship, I have no.
Tomorrow you'll say, even though if any law is there, you'll say it's a gazette notification. How come I know? It is not expected from the government to convey each and every citizen that we have notified this or these are the law.
What has fallen from your lordship's mouth, your lordship, I bow down to it, your lordship. But my point is this, your lordship, how can it be applicable only in respect of the tenderers, not to the, your lordship, tendering authority? And that's what Honorable Single Judge has, your lordship, discussed.
This is not the, is this the reasoning of the learned single?
Yes, your lordship will kindly para 24, your lordship.
Reasoning then somewhat.
If you succeed in that argument, then there could be action against the tendering authority, but the settlement cannot be set aside, even if you succeed in this argument.
No, lordship will kindly see that if your lordship, in the entire process,
Yeah, where is
lordship,
that?
para 25, your lordship.
25, yeah.
Sri Sharma, Learned State Council has strenuously argued that this gazette notification is of the year 2018 and NIT is of the year 2021. And therefore, it cannot be assumed that all the intending tenderers are not aware of the requirement of law. Now, however, having taken into consideration, this court also cannot ignore that condition of the gazette notification which requires that all ensuing tender process have to incorporate the conditions given in the gazette notification, which admittedly has not been done. It is right law that while applying a notification, it cannot be done in a way that only those in favor of the state would be made applicable and those which against it cannot be applied. If the gazette notification is actually held to be applicable, the same has to be made applicable whole log and not part of it.
Yes.
Lordship. Now, therefore, your lordship, in that way, your lordship, these conditions which they have applied to evaluate the tenders, your lordship, of the tenders, your lordship, these were not known, not disclosed, your lordship. Ultimately, they have applied this as an hidden criteria, your lordship. Had it been disclosed that they will apply not even the conditions, if they have said that this tendering process will be governed by the notification dated 18 January 2018, then I am out, Your Lordship. I don't have any case. But that has also not been disclosed. They have kept everything.
But you do agree that your client's bid did not comply with the 2018.
No,
There is no,
no,
there is no quarrel about that.
no
na?
quarrel about that. Your Lordship. That's, I agree. But Your Lordship,
So the only question is,
whether
merely because it is gazette notified, could the tendering authority have stuck to adhere to that? Or unless it was put as a part of the tender
Tender.
condition, it would have no relevance.
no
That is the argument.
That's my argument. Your Lordship. That's Your Lordship. By that way, Your Lordship, arbitrariness creeps into the decision-making process. Your Lordship. That's my argument. Your Lordship. That's my, and Your Lordship, so far as Your Lordship,
Sure.
I am Your Lordship substituting. Problem, Your Lordship. I am substitute player, Your Lordship. Here, Your Lordship. It
But
was
you played well.
I feel obliged. Your Lordship.
And my
And
lord
this-
has understood fish much faster than what I thought. Despite the natural issues.
It's not substitution, it's an impact player. Now, in this IPL, my lord, this system has been introduced.
Some days before I was looking a clip of on WhatsApp. There was a substitute player in the football match. And in 15 minutes, he scored 5 goals. So he is almost nearer to that, but
Yes,
it seems he is now scoring the 6th goal.
Right. This is one judgment, Your Lordship, of the division bench of this, I report, Your Lordship. Raidak Burachora Fishery Cooperative Society Limited, Your Lordship. The Honorable Justice S. Syam has passed the single judge bench order, Your Lordship. That was put to challenge, Your Lordship.
No.
In para 8, Your Lordship. 2017 SSC Online Guwahati 960, Your Lordship, the division bench. Right, only one paragraph. There is no gainsaying that the settlement of fisheries must conform and fulfill the object of the fishery rules. In doing so, it is incumbent upon the respondent settling the authority to make such inquiries in order to reach satisfaction that not only the most deserving group is given settlement, but also to ensure that the interest of government revenue is adequately protected. In the present case, if a technical shortcoming that neighborhood distance certificate in respect to 5 villages did not accompany tender form, the appellant does not dispute the fact that the respondent number 6 society is located in the neighborhood of so and so. It is a fact that the respondent number 6 offered much higher bid than the appellant, which ensures that the interest of the government revenue, therefore, just from whichever angle, the respondent number 6 society is clearly the most deserving tender for being conferred with the order of settlement. Now, Your Lordship, the object, Your Lordship, is also one, Your Lordship, to protect the government revenue, Your Lordship. And it is an admitted position that, Your Lordship, I have quoted a rate much higher than that of the appellant, Your Lordship.
But this argument is somewhat not acceptable. If the government, the aim is to collect the revenue, then certainly they could not have restricted this tender process system to the residents of that area.
No,
They
Your
could have
Lordship.
asked, many big players could have come there and they offered more much.
There are two objects, Your Lordship. One is to, Your Lordship, ensure that the employment to those people, Your Lordship, belonging to scheduled caste, Your Lordship, in the neighborhood of the fisheries, and then to augment the revenue, Your Lordship. And in the context of that, Your Lordship, we will have to look into the notification issued in the year 2018, Your Lordship. And that's why, Your Lordship, the notification itself says to protect and to augment and to increase the revenue of the state. Now, in a way, it has been applied, Your Lordship, that it reduces the revenue, Your Lordship.
Yes.
Lordship, in view of that, Your Lordship, the entire case ultimately, Your Lordship, although three conditions are referred to, Your Lordship, the violation of three conditions, Your Lordship, then ultimately it all boils down to this particular notification. First two conditions of the, Your Lordship, which allegedly I have violated, Your Lordship, we have violated, Your Lordship, those relates to, Your Lordship, this particular tender notice, Your Lordship. But this particular, Your Lordship, notification, Your Lordship. Now, third ground, Your Lordship, that in my humble submission, there is no requirement, Your Lordship, to submit any authority letter, Your Lordship. But still they have applied that, Your Lordship. আমার তো দেখতে
দাদাকে তার প্রমাণ জানতে জেলা তোমার লিখবো 2021 2 GLR 724 2021 2 GLR 21 और 2 নম্বর
Yes.
Lordship, so far as the issue of Your Lordship is fishing experience certificate issued by in the name of President of the Society, Your Lordship. That judgment of Pub Gwalpura division by judgment, Your Lordship, para 13 days with it, Lordship. But your lordship, I have this copy, your lordship, downloaded from the website of this. Para 13 dealt with that, your lordship.
Yeah.
Para 13, in the order dated 20th December 2018, granting settlement to the appellant insofar as the bid offered by the respondent number 8 writ petitioner is concerned, it is seen that the first ground of rejection of the respondent number 8 writ petitioner tender is that fishing experience certificate submitted by the respondent number 8 writ petitioner. The respondent authorities have rejected the fishing experience certificate on the ground that same had been issued in the name of the president of the society which does not cover all the members of the society. Upon perusal of the said certificate, it is seen that the same was issued in the name of the lead and president, namely Govinda Chandra Das, Malegaon Govindapur Fishery Cooperative Society Limited. A perusal of the said certificate, it is seen that the said fishery has been certified to the ample experience in fishing and other related activities like marketing and are fully involved in such activities for the past 20 years. The said certificate was issued by the District Fishery Development Officer, Bongaigaon, by issue number so-and-so dated 26/2018. A copy of the registration certificate issued by the Assistant Registrar of Cooperative Societies, Gwalpara, in the name of Govindapur Cooperative Society is also enclosed to the writ petition as revealed from the pleadings. As per the registration certificate of the society was registered by number so-and-so dated 9 February 2020. The area of operation of society is also reflected in the certificate, namely so-and-so, so-and-so, so-and-so. As such, merely because the fishing certificate was issued in the name of president, it cannot be said that same does not reflect the fishing experience of the cooperative society. Now, your lordship, coming back to that notification, your lordship, I just want to point out one thing that may not directly related to my case, your lordship. What has been happening, your lordship? They are in none of the tenders here, they are putting these conditions, your lordship. Now, what they are doing, your lordship, in some cases they are applying this, your lordship. In some cases they are not applying it, your lordship. So, your lordship, the very purpose of not incorporating to avoid this kind of, your lordship, things by the acts by the authorities, your lordship, it was.
So is there proof that they have not applied it in another?
No, your lordship, that's why I am saying, your lordship, that this is not directly related to my case, since I have not pleaded that case.
No, Mr. Potapu, if you can show us.
Lordship.
See, as we have said, violation of Article 14 is the sole basis of
Lordship.
interference in this matter. They can't discriminate. They can't treat one party unfairly. If the process adopted is otherwise fair, conforms to some set principle, the courts will not interfere, even if another way was possible. That's the principle. It is not about who's getting the tender, who is not. We are not concerned. Now, if you can show that the government in the fishery department around the same time had processed another tender where they've ignored the clauses of this circular, then the matter will be entirely different.
For that, your lordship, I will need some time, your lordship. Right now, we cannot, your lordship. And since this is
some
not
other case.
pleaded, your lordship,
some
therefore I have stated at the very beginning that this is not related to my directly
some
related
other
to my
case.
lordship.
Well, on this point, it's clearly covered by Supreme Court judgment. That's why I didn't show it at the beginning regarding, my lord, not inclusion in the tender the clauses. Once it is a gazette publication is there, my lord, then a subordinate legislation becomes effective. My lord, there's a very famous judgment, D.K. Srinivasan versus State of Karnataka, 1987, 1 SCC 658. Para 15. 1987, 1 SCC 658.
Yes.
When does a subordinate legislation take effect? Well, Lord, somewhere in the middle, this sentence starting with, but unlike parliamentary legislation, at
Para
page
8.
672, para 15. But unlike parliamentary legislation, somewhere in the middle at para 15. Can I read it, madam?
Yeah.
But unlike a parliamentary legislation which is publicly made, delegated or subordinate legislation is often made unobtrusively in the chambers of a minister, a secretary of government or other dignitaries. It is therefore necessary that subordinate legislation in order to take effect must be published or promulgated in some suitable manner, whether such publication or promulgation is prescribed by the parent statute or not. It will then take effect from the date of such publication or promulgation. Where the parent statute prescribes the mode of publication or promulgation, that mode must be followed. Where the parent statute is silent, the subordinate legislation itself prescribes the manner of publication. Such mode of publication may be sufficient if reasonable. If subordinate legislation does not prescribe the mode of publication, or if the subordinate legislation prescribes a plainly unreasonable mode of publication, it will take effect only when it is published through the customarily recognized official channel, namely official gazette or some other reasonable mode of publication. So once there is a publication in the gazette, then it will take effect. And my lord, here in this case, this is of 18/1/18 and the tender was of 2021. Now, my lord, regarding the other point, I think Honorable Justice Shuman Sham had rendered one judgment where it was in the context of Rule 13, where my lord, and in respect of a 40% fishery, not 60%, where my lord, in case of a 40% fishery, everybody can compete, whether he's an individual or he's a cooperative society. But there are certain, by virtue of 2-3 provisos, my lord, some benefit is given to persons belonging to the backward communities if their bid is within 7% of the original bid. Now there I appeared for the gentleman called Manoj Sahani who bidded a higher bid. Now the judgment was, my lord, this is, my lord, 2021 2 GLR 724. My lord, against your lordship's order, I succeeded in before division bench. In Supreme Court, the lordship's order has been upheld. I am referring to that para 29. Para 29.
Yes.
It is no doubt correct that in a tender process, the highest bidder would ordinarily enter in a legitimate expectation to receive the order of settlement in his favor. However, legitimate expectation is not a right that is enforceable in the eye of law. What is also is to be borne in mind that unlike in case of an ordinarily commercial tender, a tender for settlement of fishery floated under the rule of 53 stands in a different footing. In a fishery settlement process initiated under rule of 53, highest bidder cannot always claim to have indefeasible right to beg an order of settlement. This is because an order of settlement of fishery under rule 53 is not only required to be in consonance with the letter and spirit of the rule, but the same must be also at realizing avowed objective of the fishery rule. If an order of settlement meets the requirement of the fishery rule and is issued for cause and reason, same is in the opinion of the court, cannot be termed as arbitrary merely because settlement in a given case has not been made in favor of the highest bidder. Therefore, having regard to the purport and import of the rules of 53, protection, if any, available to a highest bidder in a fishery settlement tender has to be essentially remain confined to questions of transparency and fairness in the tender process. Division bench, we succeeded, my lord. The other side went to Supreme Court. Justice Rohington Falinariman has rendered the judgment. The single judge order was upheld. That is the order of the Supreme Court, my lord. Of course, it was passed by Honorable Justice Gavai. Stay was given by Rohington Nariman, my lord. If your lordship will kindly come to page 2. However, the learned judges of the division bench by the interim judgment and order set aside the same. We find that when the learned judge by an elaborate and correct reasoning had upheld the decision of the state government, the learned judge of the division bench could not have interfered with the same unless the finding was found to be perverse or impossible. The appeal is therefore allowed. The impugned judgment order passed by the learned division bench is quashed and set aside. The judgment and order passed by the learned single judge is affirmed. So, my lord, it's a salutary provision, my lord, under the rules of 53, where, yes, definitely, my lord, high bid is necessarily a consideration, but that can't be the only consideration. So in that view of the matter, my lord, I think the settling authority has not committed any error in preferring the appellant before over the lead petitioner who though offered higher bid. And my lord, the learned single judge, in my humble submission, ought not to have interfered with the settlement.
Confusion order is based on reasonable. I wouldn't say I have fixed. Really don't know that we.
यार होने गया
Actually,
अलग है लॉन्ग के पास मत ही लॉन्ग के पास मत ही है वही वो ना
undisclosed criteria. You want to choose that they actually use immediate notification differential. It should be. Right, but we have to stick to the ground rules. Legally, facts get
Yes,
That is our submission, madam.
yes, Mr. Botagur.
Lords.
Comment anything?
He wants to convey that you are making submission on behalf of the state. Why should we?
State settlement. Whole night there was no current, my lord. Whole night there was no current.
Yeah, I mean.
Later part, even the inverters were not working, and today also it is unlikely that we'll have current. I've checked up with the SAB, he said not, even now it's raining.
Yeah, that's right. Then shifted to some five-star hotel वगैरह. इनको भी ले जाओ सबको बैठे हैं जो.
Is it a mandamar?
Had it been a case of no rains, definitely would have to go. But it was raining, therefore little bit of respite from the heat.
Okay. Now, anything urgent today?
No, man. There are one matter is not today, man. Even we are also little bit tired.
I think 3940 million. And
Yeah.
These two matters, there is some urgency below.
Okay, next week.
Next week, if we
My lord, instead of next week, following week, my lord. Next week I have some difficult, following week.
June 1st week.
June 1st.
Item number 41, this one be taken off.
My lord, it can be on 10th, my lord.
Okay, fine. Yes, Mr. Das.
Fine, man.
10th June, 39 and 40.
Item
Yes.
number 41, this will be taken on Thursday. Lord.
Thursday, 41.
Yes. We need to go on.
41 items.
4th June, if.
You want on 4th June?
Yes.
You don't want to see TV?
4th June.
Lordship, item number 43 may come up after 2 weeks, Lordship.
You please ask the coast marshal. They'll give you.
In regard to item number 44, Lordship.
Yeah.
My fingerprint is also here, Lordship. In the last 3-4 occasions, due to paucity of time, this matter couldn't be.
On 10th, my lord.
Lordship, day after tomorrow.
No, there are more cases. Let me on 10th, my lord.
10th.